I don't know. I don't know for lodging. I don't agree that is not the record.
Repetition, my lord, eviction method, it was filed 11/9. May come tomorrow, my lord.
My please, Lordship. Mention for listing 25.
What?
A matter is a forest matter.
Why do you want
In
to-
admission stage, my lord. Last, it was posted last on 27/6/2024.
What is the urgency?
It is going on day by day. Time is going.
No, do it after vacations. No, no. We have only 1 week left. 1 week not possible. There are already a lot of matters fixed.
After
Lord, in eviction matter, the cause of action is similar to the item numbers 45 and 46 before lordship today. May I pay for unlisted as a motion item? I'm okay.
May I please your lordship? Lordship, yesterday I filed this matter. Lordship, please listed the matter for tomorrow.
What?
Listed the matter for tomorrow. I filed the matter yesterday.
What? Writ petition?
Writ petition.
For what?
Land sale. For land sale. Thank you. Like this, your lordship, we have reply, affidavit reply on 17. So let record is not in text, lordship. Item number 6.
Item number
6.
17.
6. Item number 6.
What is this?
Yes, writ petition is a text matter.
What do you want?
We want the record to be in the file. The affidavit reply. We have already filed an affidavit in reply.
May I please, Lordship? Lordship, I declaration item number 17, Lordship. In this matter, Lordship, Learned Senior Counsel Didas will lead this case, Lordship, in this case, Lordship. So, Learned Senior Counsel Didas will appear in this case, Lordship. So, I am paying for Lordship. I have informed the side also, Lordship.
17.
17,
After vacation.
Lordship.
Urgency is there.
Urgency is there, madam. Otherwise,
We'll take it up. Urgency is there.
no. If it is not today, my lord, then kindly date may be fixed. Can you get it from Daniel?
Well, what is the urgency?
There is an interim order. They are enjoying an interim protection. Matter pertains to Madam Pirola Kotto in Kolkata, which has been illegally enclosed by enforcers. Now, record has been corrected and eviction notices have been issued. And under that circumstances, there is a clear finding of the coordinate bench of this honorable court also in similar matter. This is the second round of litigation. That's only date may be fixed, my lord.
We'll take it up. Don't worry.
Loss.
You want an upgradation?
No loss.
Then?
Yes,
Then don't mention. It
Yeah.
may not. It may not likely to reach.
Fine.
But if it reaches, I'll take it.
Fine. Bless.
Yeah, please, Lordship. Lordship, this matter was listed on 22nd May 2024, and it was directed to be listed after 2 weeks, Lordship. But subsequently, it was not listed. Lordship, maybe please to list it on next day, on next week, Lordship.
After vacation, you go and mention it.
Application.
It matters or not, because if it is fixed after 2 weeks, meaning thereby the court has not fixed the date.
But it was first listed on 22nd May 2024.
Thereafter, the court did not fix a date.
But it was directed to fix a date after 2 weeks.
That is why, no, I always keep on fixing dates, seeing the urgency. But if there is no urgency shown at that point of time, you did not have it after vacation. No heavens is going to come.
For vacation. God bless you.
Yes. Record only shows that on one date, notice was there. There is no application filed by them. The record says that.
But our
My client said that their application was there.
Huh?
Well, the petitioner said that their objection was there, my lord, but consider.
Why don't you file an appeal against that? There is no
My
appeal.
lord, I filed a petition before the deputy commissioner, but they say that, my lord, the record is not traceable. In the affidavit also they said, no, at the relevant time, record was not traceable. And the notice was affixed on in the notice board that while shifting the office from new building, old building to new building, some records are not.
Now, against this order, an appeal lies.
Yes.
Appeal like- But my lord, one thing, my lord, since my lord, rule 10, 11, 12 are completely violated, my lord, rule 11, my lord, rule 10, 11 and has been, my lord, 12 has completely, my lord, not followed. My lord, rule 11 says, my lord, that the deputy commissioner has to make a memorandum of evidence also, my lord. There is nothing, my lord, on the very same day, my lord, he has considered, heard the party, he has considered the compensation, he has allowed the, my lord, record collection, my lord, on one date, my lord, how it can. My lord, violation is there, man. And there is a judgment of, my lord, this one report also, my lord. Reported in 2007, CLR page and that.
Did you submit the objection? No.
Yes, my lord, I submitted.
Show me the deputy commissioner's order.
Original page 25.
29.
25. It start from page 25.
We do one thing.
My lord,
As now the file has been reached,
my lord,
we send you to the deputy commissioner.
Well.
And restore the file of the appeal to the deputy commissioner.
Well.
And direct the deputy commissioner to take on record your statement, which is there in the memo of appeal, and to decide whether to decide by himself or
Or
to
yes,
release.
yes,
I think that would be a fair thing
my lord,
to do, taking into account the an appeal provision was there, because
Well-
once an appeal is there,
Well-
then you are entitled to, and on the ground of alternative remedy, I dismiss it, holding it and not entertaining, holding it, that provision is an efficacious remedy. So all the points which are raised here can be raised.
yes, that is it.
I think would be better. Don't you think?
No,
Huh?
no, my lord. My lord, it can be, my lord, remitted back to the deputy commissioner to
No,
decide.
that is why I'm saying, if that can be, that is one, I think that is a better option.
Well-
Thereby keeping all your options open before the deputy commissioner. Now the file they have got.
Well-
The reason why this was done is that the file was not
My,
there.
my,
I think that is a better option.
my lord.
My lord, as per section 59, there is a appeal provision which lies to
That's why.
director of the networks.
Understood?
Yes.
The appeal provision is there. He moved an appeal. The appeal was not entertained, taking into account this. Kindly see page 34.
Yes.
This is to inform that file number so and so is missing from the office of the deputy commissioner Leno. In spite of the repeated search, the file is not found. The file may be misplaced during the shifting. All employees are requested to deposit this. Now thereupon nothing happened.
My lord.
So the appeal is there. This is an appeal.
My lord, appeal, or it may be a review petition, whatever it may be.
Not an
I'll-
appeal.
It's a review.
Review, my lord, because appeal lies before the board of review.
Appeal lies before the board of revenue.
It was
And this order was passed by the
additional deputy commissioner on behalf of.
additional deputy commissioner. So additional deputy commissioner and appeal lies to the board of revenue.
Well-
So we do that, giving you the liberty out there to raise all your issues there better on. Now as the file has been
Yes,
traced
yes,
down.
my lord.
Uh, how was the record traced out?
Lordship. Not affidavit, Lordship.
Because here the most important thing is that document, the written objection which is there is the question. They say that we have submitted the written objection, that the order which has been passed is that there is no written objection.
In the record also, I don't find it.
This is done under the what act? 71.
Yes,
71.
You show me the 71 act. You are referring to which provision?
My lord, rule 10 says, my lord. My lord, 10 is a, my lord, disposal of the application for acquisition filed by the tenant, my lord. And 11 proceeding for acquisition. 10, my lord, maybe, my lord, we can say that 10 is complied with, but so far 11 is concerned, my lord. Very good.
Deputy Commissioner shall hear all objections presented within 1 month of the service and make a memorandum of evidence, if any, adduced by the parties, and shall, for the purpose of inquiry, have all the powers of the civil court. Here there is no memorandum
No,
of
nothing
evidence,
much.
means there is no, without
My-
taking evidence, he has done it.
Hearing was there.
No evidence,
No, there.
no evidence. Without evidence, how could he have come to a decision? Whether he has filed an objection or not, that is immaterial. But without objection, without evidence, how could the authority pass an order? He need not take down each evidence like ABCD, that so and so, and it's not required. But then also it is required to have a memorandum of evidence, which is similar to Order 18 Rule 5.
Must-
Huh? Yes. Without that, how did this order be passed? No.
Circle officers report was also there.
Can that be only on the basis of a circular officer's report? There has to be a memorandum of evidence. Some evidence has to be given by you that you are residing out there. You are staying out there, that you have been, therefore you are claiming ownership under 25 or 23. 25, you are claiming ownership. Now,
23, man, 23,
you are doing it under what provision?
23, man.
23 euros.
23.
And section 25 is also adhered to the compensation was paid.
Acquisition, any occupancy tenant personally cultivating in a land of his tenancy, desirous of acquiring the ownership title of it, may at any time make an application in writing to the Deputy Commissioner. On such application being made and compensation as provided under ER is determined and paid by the operator, the Deputy Commissioner shall declare the owner has acquired the title, and under tenant, under so and so cultivating in so and so. The total compensation payable for acquiring of the land is so and so. Procedure. Apportionment of the compensation. 25 is apportionment, we are not concerned. Yes. 23. Then procedure for acquisition of title, disposal of an application filed by tenant. The Deputy Commissioner on receipt of an application shall cause an inquiry to satisfy himself about the eligibility of the applicant to acquire the intermediary and ownership before ordering the person. If the EI is satisfied that there is a prima facie case for acquisition under 20, he shall serve notice on the Form 6 to the Iman and also to the person in whose opinion so and so shall hear all objections so and so, allowing acquisition. When the Deputy Commissioner allow the parcel, he shall record a formal order in the proceedings to the effect that so and so. Declaration. No, this inquiry has to be initiated, which must have been the circle officer's report. For initiation of the proceedings as per 10. And therefore that was there. But there is no evidence, other evidence taken.
And my lord, perhaps, my lord, there is no inquiry as per rule 10. Well, rule 10 says, well, prior to issuance of notice in form 6, he has to make inquiry. Well, there is nothing on record that prior to issuance of notice in form 6.
Show
there
me
was
the
an
record whether any inquiry was made. Let's see.
It is only thereafter, my lord, the report from circular officer was given.
Give it to me. I'll be faster. Because of the circle officer's report, he proceeded. Heard Mr. J.C. Gord, the learned counsel appearing on behalf of the petitioner. Mr. N. Goswami appears on behalf of the respondent numbers. Mr. A. Vachaji appears for the respondent number 1. Mr. N. Goswami appears for the respondent number 2 and 3. And you are appearing for 4 to 8? 4 to 8. Mr. So-and-so appears for the respondent number 4 to 8. The instant proceedings have been in the petitioner herein have assailed the order dated 25/11/2019 passed by the respondent number 3 in tenancy case number 7/2019. The present petition under Article 2 to 6 of the Constitution is filed challenging the order dated 25/11/2019 passed by the respondent number 3 in tenancy case number 7/2019, whereby the respondent numbers 4 to 8 who were the recorded riots were granted the ownership rights in terms with section 23 of the Assam temporarily settled areas Tenancy Act 1971. Pusta. The challenge made to the instant proceedings to the said order is primarily based on two grounds. First, that the petitioner herein had submitted an objection to the said in the said proceedings. However, the said objections was not taken into account. The second ground, which have been as ground taken, is that there is no compliance to Rule 10 and 11 of the Assam temporarily settled area tenancy rules 1972, for short, the rules of 1972. Inasmuch as it is the case of the petitioners that the respondent number 3 have merely disposed of allowed the application filed under section 23 of the Act of 1971 on the ground that there was no objection so filed by the respondents, by the petitioner, and without even making any attempt to record the memorandum of evidence. This court, by an order dated, this court also finds it relevant to take note of that pursuant to the order dated 25/11/2019, the petitioner had filed an application before the Deputy Commissioner, where Kamrup Rural, seeking a review of the order dated 25/11/2019 on the ground that the petitioner have duly submitted an objection which was not taken into account. The said proceedings, however, was not further proceeded with taking into account the file wherein the order dated 25/11/2019 was passed, was being file number KRL 7/2019 was missing. This aspect of the matter is clear from Annexure E to the writ petition. In the backdrop of the above, this court have also finds it relevant to take note of the records which were produced by Mr. N. Goswami, the learned counsel appearing on behalf of the respondent number 2 and 3. This court had inquired with the learned counsel as to when the file being KRL 7/2019 could be traced out. However, he had no instructions, any instruction.
The paragraph 5 of our activity started logic.
However, he submitted that the said file was
Time of
Time is not mentioned there. So, Honorable Court is asking for-
where?
paragraph 5. Date is not there.
The deponent Bexu state are the legal head. No, paragraph 5 of whose affidavit? Your affidavit, no? Paragraph 5.
What is true?
When he submits that there is no specific instruction as to when the file was traced out, but in the affidavit, so filed by the respondent number 1 and 2, it has been filed by the respondent number 2. Who? By the respondent number 2 on 19th of October 2022, it has been mentioned that the file was misplaced due to shifting of the office from the old building to the new building. But however, the file could be traced out and it is available with the concerned branch. This court have also perused the said records of KRL number 7/2019 19, na?
19, my lord, sorry.
KRL 19, which was produced by the learned counsel appearing on behalf of the respondent number 2 and 3. Pusto. From a perusal of the said file, it is apparent there is no such objection, however, on record. Pusto. This court also have taken notice of the fact that the order passed on 25/11/2019, as well as the preceding orders after the initiation of the proceedings by an order dated 14/11/2019. Now, this court have also further perused the entire records which of KRL number 9/7/2019. From the records, it reveals that on 14/11/2019, there was a direction to issue notice upon the petitioners, thereby fixing the matter on 20/11/2019. On the said date, it has been mentioned on 20/11/2019, it has been mentioned that though the petitioners were represented by their respective counsel, but when the matter was taken up, nobody was present. And accordingly, the matter was fixed on 25/11/2019. On 25/11/2019, the learned additional deputy, the additional deputy commissioner, the respondent number 3, have passed an order on the basis that there was no objection filed. And on the very day, the compensation was also adjudicated in terms with Section 24 of the Act of 1975. 71. And the rights in respect to the said land was also conferred. The ownership right in respect to the said land was also conferred to the petitioner, to the respondent numbers 4 to 8. This court is this court expresses anguish and surprise in the manner in which, in the haste in which the said proceedings was initiated and concluded. It is also very pertinent to mention that while passing the order dated 25/11/2019, the ADC have not taken note of Rule 11 of the rules of 1972, wherein there is a requirement of making a memorandum of evidence, if any, adduced by the parties. It is also seen that merely on the basis of the application filed by the respondent numbers 4 to 8, and on the basis of the circle officer's report, the said order was passed. Taking an overall view of the matter, and the fact that by virtue of Section 23, the ownership rights of the petitioner have been taken away and given and conferred upon the private respondents. It is the opinion of this court that the ends of justice would meet if the petitioner, if a direction is issued to the additional deputy commissioner to carry out a de novo adjudication in respect to the application so filed by the respondent numbers 4, 8, Full stop. This court accordingly full stop. This court further grants the liberty to the petitioner to submit their written objection on the date so to be fixed. I'll read the objection. Full stop. Accordingly, this court, accordingly, the instant petition stands disposed of, thereby interfering with the order dated 25/11/2019. Full stop. This court further directs the additional deputy commissioner Kamrul Rural to de novo initiate decide the said proceedings being KRL number 7/2019. Full stop. The petitioners herein are given 15 days time from today to submit their objection. Full stop. This court, however, makes it clear that the additional deputy commissioner shall decide the said proceedings in accordance with the provisions of the Act of 1971 and the rules of 1972. Full stop. With the above, the instant proceeding stands disposed. The records which have been produced is returned. Yes, Mr. Chaudhary.
Yes. Wait, Peter.
Yeah.
Well, I've made a small list of dates. Few dates are relevant. I'll address your lordships on Locust Point and the other aspects.
Yes.
3rd of January 2020, FIR lodged by the petitioner number 2 against respondent number 8 under section 354 of the IPC, read with section 10 of the POX code. Then subdivisional judicial magistrate allowed the prayer of investigation officer to add provisions of section 354A and section 3.
Record to good. Yeah, record to us.
Then my lord, order passed, we came to the High Court. Order passed by the Honorable Chief Justice in criminal petition number so directing investigating officer to ascertain whether the petitioner number 1 belongs to SC category by referring to her birth certificate, school certificate, and other related documents. Petitioner number 2 applies for caste certificate before the deputy commissioner comes
This direction was given to whom?
by the investigating officer. Then at 10/8/2020.
Police is going to investigate. The police is going to investigate. Then
Petitioner number 1 applies for caste certificate before All Assam Tribal Sangha. 21/8/2020, affidavit filed by Inspector General of Police, CID in criminal petition wherein it was stated that no caste certificate of petitioner number 1 was available. Caste certificate issued by the Deputy Commissioner on the same date. Legal notice issued to Deputy Commissioner against issuance of caste certificate. Caste certificate cancelled by the Deputy Commissioner. Cancellation order revoked by the Deputy Commissioner. Matter referred to the state level scrutiny committee. Order passed in the WPC number wherein it was observed that state level scrutiny committee is competent body to determine the question of validity of the caste certificate of the
but
petitioner.
Mr. Chaudhary, this order of 2110
Yes,
is an order actually not stating anything to that effect. What it states is that when there was a challenge being made to the cancellation made by the deputy commissioner, there was the council who was appearing for the government came up that we have already cancelled it. It is in that context
No,
an
but there is-
observation.
No, there is one more very relevant direction in that case. That until and unless the state level scrutiny committee decides the issue, the 89 Act provisions cannot be invoked.
Yeah, that is on another matter.
No, in that matter. Highly similar.
This matter,
Yes, same. Yes.
no, that is in your writ petition.
In my writ petition.
Yes. No, that I understand. In your writ petition, there is a specific order to that effect
Yes,
that you kindly don't go ahead
Investigate.
with an investigation on the basis of without the finalization of the caste certificate
proceeding
by
before
itself.
the state level scrutiny committee. Yes. Then my lord, these 3 dates, 12/11/20, 23/4/21, 17/6/21. It was the state level scrutiny committee who asked the respondent number 8 to be present before the committee, before the hearing. We never intervened in that proceeding, my lord. We were asked to be present. Then order passed by the state level scrutiny committee, that is page 16. Now, my lord, here is a case. The present petitioner number 1 and 2, they never had any caste certificate.
I'll give you the exact dates. what
Yes.
the- How it proceeded. You see, from the records, it seems that on 1/2/2021, the petitioner number 2 submitted the order dated 21/1/2021, passing the writ appeal. Because writ appeal directed that within 15 days you decide. At that time, there was no vigilance report. The file noting dated 2/2/2021 shows that the department had sought for a report from the Vigilance Committee, but the same was not received. It is further seen from the file noting dated 16/3/2021 that a report of the Superintendent of the Police CID Assam was submitted by the Director WPT and BC Department of the Government of Assam. Thereupon, the SLEC was convened on 27/4/2021.
Yes.
As would appear from the file noting dated 26/4/2021, and the petitioner number 2 was directed to be informed. The petitioner number 2, on coming to learn about the same, issued a letter requesting the SLC not to call the petitioner number 1 as well as the respondent number 8 on the same day, keeping in mind that the petitioner number 1 was a minor and a victim of sexual assault by the respondent number 8. On the same date, the petitioner number 2 had also submitted her written statement. Thereafter, another date was fixed for the respondent number 8 for his hearing. It further transpires for the record that on 25/6/2021, the respondent number 8 was heard. On that very day, the respondent number 8 submitted a supplementary objection dated 25/6/2021. Subsequent thereto, the respondent number 8 submitted another objection on 28/6/2021. The file notings are absolutely silent as to whether the supplementary objection as well as the objections filed on 25/6/2021 and 28/6/2021 respectively were furnished to either of the petitioners. In fact, the file noting dated 8/7/2021 shows that the respondent number 8 was heard and written statement was taken on record and a draft speaking order was put on 8/7/2021. Subsequent thereto, the draft speaking order was made and the speaking order was signed on 29/9/2020.
Yes. No, my lord, we are not privy to all these dates. Other than that, we filed 2 objections.
You were privy to the fact that you appeared subsequently submitted to objections.
Yes, to that extent I am. Beyond that, my lord, we are not privy because that's a part of the record. Now, my lord, one question has been raised by this honorable court, relying on that Ayub Khan Nur Khan's case, that we do not have, whether we have locus standi to at all interfere in this case. My lord, here is a case.
I would not touch, I'm telling you, I'm not going to touch on that aspect to that extent. because there is already a division bench order.
Yes.
I cannot. But the fact that, could you have at all, I'm not saying anything to that effect, is that the mandate of law that anybody else can apply?
Okay.
That is
Now,
the
now,
question.
now here is a case, my lord. Now, I appreciate. Lordship will kindly appreciate one aspect of the matter. It all depends upon the facts of each case. In fact, my lord, even if we go by the Ramesh Bhai's case, what is the ratio? Ratio is if a scheduled tribe or a scheduled caste marries a non-scheduled caste or a scheduled tribe, then the children which will emerge out of the wedlock, whether that children would take the caste of the mother, that will depend upon the facts of each case. That is the first ratio. And the second is, my lord, that it all depends whether, sorry, ordinarily the presumption would be the child will take the father's caste. But that is a rebuttable presumption. If it can be shown that the child never had a advantageous start in life, that they have to undergo all the indignities, disadvantages, in that case, they can still be considered as scheduled tribe or scheduled caste. So that is the ratio. Now, Valsama was a case where without any discussion, a view was taken the moment a scheduled caste or a scheduled tribe or a non-scheduled caste or a non-scheduled tribe marries a scheduled caste or a scheduled tribe, then the wife automatically takes over the caste of the husband. So that is
This
not
is a voluntary act.
voluntary.
This is a very
So
important.
so that law has been, in later judgments, the Honorable Court says this is not the correct view. Eventually, as on date, my lord, what is considered to be correct law by the preponderance of the view of the authority of the Supreme Court is Ramesh Bhai is holding the same. Now, Ramesh Bhai, para 54 to 55, 4 and 55 are the ratio. Para 48 is not the ratio, my lord. That was a question which the Honorable Supreme Court posed. But that what the question which was posed in para 48 was not answered. Eventually, it was answered in para 54 and 55. That is my humble understanding. Now, coming to the point of whether somebody else can interfere in such a matter, a question which has fallen from your lordship, my humble understanding, my humble submission is, in an adversarial litigation, the concept of locus standi has to receive a very liberal interpretation. Now, kindly come to the facts of the present case. Initially, when the FIR was lodged, it was an allegation of 354. Now, subsequently, this Scheduled Caste Act of 89 was sought to be invoked. It was at that point of time, several litigations ensued. Eventually, we are before your lordship. Now, the question is, don't I have a right to, defend myself? In trying to defend myself,
You defend it here.
I'm saying is, in trying to defend myself, am I not entitled to question some of the moves of the other side? Because it is an adversarial litigation. Because an act which does not apply is sought to be made applicable to me. I have a right to resist. In the process of resisting, am I not entitled to also question how come you are trying to bring these actions against me? That is what I have done. End of the day, when it comes to state level scrutiny committee, I never, went there voluntarily. It was the state level scrutiny committee who said, you please come and, give your version. So therefore, and now kindly see, my lord, a decision is an authority for what it actually decides. If your lordship kindly comes to the Ayub Khan Noor Khan's case, I'll just place that 2 paragraphs from the judgment. Please take the judgment, my lord. I'll refer to para 2, 3, 4 and 5 for the facts. Then para 9 is the conclusion of the Honorable Supreme Court. The facts and circumstances giving rise to this appeal are as follows. The competent authority in the present case issued a caste certificate dated 19/10/89 after following due procedure in favor of the appellant, stating that he does in fact belong to Bhil Tarvi scheduled tribe. On the basis of the said certificate, the appellant was appointed as a senior clerk in municipal corporation in Aurangabad on 6/2/1990 against the vacancy reserved for person under scheduled tribe category. The corporation referred the caste certificate to the appellant for the purpose of verification to the caste certificate scrutiny committee. The vigilance cell attached to the scrutiny committee upon conducting vigilance inquiry, while order dated found that the appellant did in fact belong to Vil Tarvi scheduled tribe, and thus the said certificate was verified. The scrutiny committee, on the basis of the said report and also other documents filed by the appellant in support of his case, issued a validity certificate dated 23/5/2000 to the appellant belonging to the Vil Tarvi scheduled tribe. After a lapse of a period of 9 years, respondent number 5 filed a complaint dated 9/1/29/2009 through an advocate before the scrutiny committee for the purpose of recalling the said validity certificate on the ground that the appellant had obtained employment by way of misrepresentation and that he does not actually belong to scheduled tribe category. In fact, the appellant professed a religion of Islam and therefore could not be a scheduled tribe. The scrutiny committee rejected the said application by order dated so, observing that it has no power to recall or to review a caste validity certificate, as there is no statutory provision that provides for the same. Aggrieved respondent number 5 challenged the order dated 13/3/09 by filing writ petition before the Bombay High Court, praying for quashing of the order dated 13/3/09 and directing scrutiny committee to hold a de novo inquiry with respect to the appellant's caste certificate. The appellant contested the said petition, denying all the allegation made by respondent number 5, while its impugned judgment dated so. The High Court disposed of the said writ petition without going into the merits of the case. However, while doing so, the High Court set aside the order dated 13/3/09 and remitted the matter to the scrutiny committee, directing it to hear all the parties concerned in accordance with law. As regards the allegation made by respondent number 5 in the complaint, it further directed committee to decide the said matter within a period of 6 months, hence the present appeal. Before proceeding further, it may also be pertinent to refer to certain subsequent development during the pendency of this appeal. This court-wide order dated 2011/2009 granted the stay with respect to the operation of the aforementioned impugned judgment, while order dated 6/1/2012, the said interim order was modified to the extent that scrutiny committee would re-examine the case on merit without being influenced by earlier proceeding before it, and by giving an adequate opportunity to the parties to lead evidence in support of their respective cases, after which the scrutiny committee will submit its report to the court within a period of 3 months. So these are the factual background, my lord. A total stranger who has got nothing to do with the, my lord, the status of the appellant before the Supreme Court, that question it was sought to be raised. It is in that context that paragraph 9, my lord, the law is laid down. It is a subtle legal proposition that a stranger cannot be permitted to meddle in any proceeding unless he satisfies the authority court that he falls in the category of aggrieved person. Only a person who has suffered or suffers from a legal injury can challenge an action order in a court of law. A writ under 226 of the Constitution is maintainable either for the purpose of enforcing a statutory or legal right, or when there is a complaint by the appellant that there has been a breach of a statutory duty on the part of the authorities. Therefore, there must be a judicially enforceable right available for enforcement, on the basis of which writ jurisdiction is resorted to. The court can, of course, enforce the performance of a statutory duty. Anyway, my lord, the issue is a person who can come to a 226 court. A person who has
No, kindly
suffered.
come to paragraph 18.
Yes. As regards respondent number, as respondent number 5 does not belong to scheduled tribe category, the garb adopted by him of serving the cause of scheduled tribe candidate who might have been deprived of their legitimate right to be considered for divorce must be considered by this court in order to determine whether respondent number 5 is in fact a legitimate person to do any claim. Yes, absolutely correct. Ma'am. Now, in the facts of this case, yes, because somebody has got a job on the strength of a particular certificate. Now, if that certificate is wrong, then he is eating up the quota of a legitimate scheduled caste. So therefore, if he is a scheduled caste, he can certainly, come to the court and say he is not entitled to get the job on the reserved category because he is not scheduled caste. That will enough to form his cause of action. Whether he succeeds or not, that's a different matter. But coming to the facts of this present case, I am a person who is sought to be, injured by application of an act. That is the Act of 1989.
But the application of the act is dependent on a caste certificate.
Lord,
Is the application of the act dependent on the caste certificate? No.
if he is not a scheduled caste, then act cannot be, invoked.
No,
in the
is it
criminal
dependent on
proceeding.
a caste certificate?
Of course,
No, it cannot be.
I'm saying it.
Because the application of the SC/ST Act, just for example, a person may not have taken the caste
No, but
certificate.
that-
Are you saying that won't
That
apply?
analogy will apply only when a children is born out of both parents who are scheduled caste or scheduled tribe. In a case where one of the parent is not, that principle will not apply. That is my humble submission. That principle will not apply.
No, that is a subject matter which could have been very well agitated in the criminal courts.
Where, my lord?
This could have been very well agitated in the
No,
civil.
I do not.
Why?
Because, my lord, as far as whether a person belongs to a scheduled tribe or not, that will be not decided by the criminal court. That will be decided by the committee. Madhuri Patil is a law in on law, is a code in itself. It's
No,
a complete-
Madhuri Patel is a case only not as regards a scheduled caste or scheduled tribe. The Madhuri Patel is a law in respect to granting of a caste certificate.
All respect, I'll sum. If I dispute that this Act of 1989 cannot be invoked in this particular case, because it entails some stringent punishment, stringent measures. So I as a citizen of this country, my lord, I have every right to protest. If a particular statute which cannot be made applicable to me, I can withstand that. That is what I have done. Now, issue is, now my lord, it's not a case where somebody is trying to get a job based on the thing. And the analogy which your lordship is trying to give would apply only when both the parents are scheduled tribe. Had it been a case, yes, why it is required? Supposing, my lord, I want to apply for a job. I want to contest election from a reserved category. Then I must produce this. I want to get some benefit under some social security scheme of the government of the day. Then I'll have to produce that certificate. So,
But do
End
you
of the
require
day-
that? Do you require that certificate for the invoking the SC/ST Act?
why that SC/ST Act was sought to be invoked? To entail some severe consequences.
That is another aspect. I'm not on that. I'm saying, does it require for SC/ST Act?
Yes, if both the parents are not, yes. If both the parents, then well, who will give the declaration that Mr. X or Y is either a scheduled caste or a scheduled tribe? He cannot claim that I am a scheduled caste. The moment he claims, I'll dispute. Now, if I raise a dispute, it has to be decided not by the criminal court or civil court. It has to be decided by the caste scrutiny committee. Supposing, my lord, in this case.
So are you saying that all these certificates now which are being issued without a decision by the caste certificate are wrong?
If a question.
Because
arises-
all matters do not go to the caste scrutiny committee.
If a question arises about legitimacy or genuineness, then it has to go before the caste committee. Now, my lord, forget everything else. Why in this case it has arisen? Please come to one letter of the mother of the petitioner, my lord. Please have this, then everything will be clear. Yes, please come to page number 391. This clinches the issue in my humble submission.
What does it say?
Yes, please come, my lord, page 391. The mother wants to show that because of the intercaste marriage, because of this reason, now she can claim this status. That is how it all started. So I have every right to object. Page 391. Everything started with this letter. on 4/8/2020.
The mother applied it.
No, kindly see on what ground? That is important. Huh? Kindly see, my lord, first subparent. However, my husband Nilutpal Lahon unfortunately expired on 4/10/12. At the time of my husband's death, my daughter and son were 6 and 2 years respectively. Since death of my husband, I have been bringing up and looking after the needs and requirements of my children as a single parent with the active support of my maternal family as per the customs and the way of life of Miri community, and as such, my child are recognized socially as members of the Miri community. It may kindly be noted that judgment passed by the Honorable Supreme Court in Ramesh Bhai, wherein it stipulates that children of a single mother can take the caste of their mother if such child is brought up by a single mother who belongs to scheduled tribe, scheduled caste and is treated as a member of the community to which the mother belongs and faces the same deprivation handicap as other members to which she belongs. So, my lord, she wants to take advantage of Ramesh Bhai, where she failed.
Yeah.
She failed.
But she's going to win here. There is no worry on that. I'm not on that.
Oh, my lord,
That
she
is,
failed
she'll
before
get
the
it.
authority.
No, she got it out there with this application.
She cannot.
She failed only in the caste scrutiny.
Oh,
She failed only in the caste scrutiny.
She was given by the deputy commissioner cancelled it. The deputy commissioner knows that I cannot cancel it. To cancel it, his appropriate authority is this.
Deputy Commissioner did not on its own cancel. When the writ petition was filed,
Of
he
course.
can.
I can all,
Yeah.
kindly see, my lord, further judgment, anyway. Therefore, my lord, now what she has to do? She has to establish in terms of para 54 of Ramesh Bhai that she was born and brought up. She never had an advantageous start in life, that she suffered all the indignities, that she suffered all the advantages. Now, what is the finding of the committee? Please come, my lord. Would your lordship sit in appeal over that? Page 66, capital A. Page 66, capital A.
Yes, tell me.
Although Dibyana A. Lahan is the offspring from a marriage between a tribal and a non-tribal, and she has been brought up by her mother, Lina Dole, there is no evidence that Dibya A. Lahan suffered disabilities, social, economical, and educational cumulatively. Srimati Lina Dole is an APS officer belonging to class 1 category in the government of Assam. She has provided a good educational
No, Mr.
facilities.
Chaudhary, this I'll take care of. This is nothing. This is absolutely contrary to Indra Swani, and all. There's no quarrel with that. That I'll take care of it. This is I'm only wanted to
Anyway,
know
Lord,
about
now-
on the
now
locus.
My submission is very simple, my lord. So far as, my lord, locus tender
No,
question. is
I am Mr. Chaudhary. I'm also saying I'm not going to allow the repetition on the basis of the locus standard. No, nothing on
Very
that.
well.
Why I'm saying so? That because I can't do it because of the division bench order.
Yes.
If it was the single bench order, I would
Yes.
have very well said that. But because division bench allowed the caste scrutiny to do it.
Yes,
But the fact remains, could he have filed it? That is the question on which I asked you to.
no, my lord, your lordship's question is very clear, in fact, which is audible to us also, intelligible to us also, my lord. Whether some person other than a particular who belongs to their caste, whether he can maintain. My lord, in my humble understanding, that there cannot be any straightforward answer to that query. It will all depend upon the facts of each case. Now, here is a case, it's an adversarial litigation where an attempt is being made by the mother of the, petitioner number 1 to invoke certain stringent provisions against me on the plea that her daughter is in scheduled tribe. As an, my lord, affected person, likely to be affected person, I have every right to defend myself. In the process of defending myself, is it not open to me to question some of the moves if it is not legitimate, if it is not in accordance with law? Now, their claim that she is a scheduled tribe, as far as petitioner number 1 and 2 is concerned, it all, emanates from that letter of the mother, which I've referred. There she claims she is entitled to that status on account of the law laid down in Ramesh Bhai. In my humble submission, my lord, that is absolutely not correct. Ramesh Bhai's proposition is totally against them. I'll place that. Now, my lord, let us come to one more passage. Please come to page 288. This was an affidavit which was filed in that criminal petition. Let us see, my lord, what does the authority say pursuant to the direction of the
Yes.
Okay. Before that, my lord, lordship may kindly permit me to place page 276, the order passed by this honorable court, my lord.
Yes.
Now, this revision was filed by the petitioner, my lord. The order starts at page number respondent number 8. It starts at 273. Please come to page 276, para 3. I hereby direct investigating officer to conduct investigation as to whether the victim belongs to SC/ST category and therefore whether penal provisions of SC/ST Act can be attracted. For the said purpose, birth certificate of the victim, school certificate appended with additional affidavit, and other related documents be referred to. The conclusion thus drawn be brought to the notice of the court along with the supporting document. Petitioner is directed to furnish the documents available with him, which might help the investigating office agency in coming to the right conclusion and the truth can be called out. It is direct. I make it clear that let investigation go on. That process of investigation does not suffer on account of pendency of this case. So, my lord, it was at my instance, my lord, this order was passed.
But that order, how does the Supreme Court say? At paragraph number 6 of that
Yes,
order,
yes.
page
My lord,
280.
Supreme Court says, page 278,
Page 280.
yes, para
paragraph
6.
Paragraph 4 and 6.
Yes. In pursuance of the above order of this court, State of Assam has appeared to so and so. Complainant, namely petitioner before the High Court, has appeared to A.M. Bora, London Senior Counsel. Roy, appearing on behalf of the state, submits that after the order of the High Court dated so and so, the investigating officer has addressed a communication to the complainant requesting her to produce any documentary material which she has in her possession having bearing on the caste status of the alleged victim, who is a minor daughter. Mr. Roy submits that investigating officer has construed the observation of the High Court in para 3 as restricting the ambit of the investigation. Roy submits that investigation is under progress. 6. We dispose of the present proceeding with clarification. The direction contained in paragraph 3 of the order of the High Court shall not constrict the duty of the investigating officer to investigate into all aspects of the complaint, nor do they confine the investigation to documentary admin. And the Supreme Court has not interdicted the High Court's order. On the contrary, say investigation will continue. Yes. Now, my lord will kindly come to the affidavit which was filed in this proceeding at page number 288. Para 3. The deponent, I think he was, my lord, CID Inspector General, yes, IGP CID. The deponent begs to state that the caste certificate issued by the competent authority in the name of the victim would have been conclusive evidence to ascertain whether she belongs to scheduled tribe community. As already submitted by the deponent in the preceding paragraph, the complainant could not produce so far any caste certificate in the name of the victim to the investigating officer. Deputy Commissioner North Lakhimpur also could not provide a copy of the caste certificate in the name of the victim, as no such certificate was issued by this office from 2009 to 31st of July 2020. The in-charge principal Kendriya Vidyalaya Karimganj has telephonically confirmed the genuineness of the documents enclosed as para A of the affidavit filed by the petitioner. However, due to the extraordinary situation arising out of COVID-19 pandemic, a written confirmation could not be issued so far by the Kendriya Vidyalaya to the investigating officer. The confirmation later would be collected by the IO from the KVS. However, in the absence of caste certificate in the name of the victim, the material collected so far by the investigating officer, as already mentioned in the preceding paras, does not support the SC/ST status claim of the victim. So this prompted them to apply for the certified copy, and which was given. Now, what is the basis? That though her father is a non-scheduled tribe, but she has been born and brought up in the way. Now, to that extent, my lord, page 66A, where the state level scrutiny committee has recorded a finding. Unless that finding is perverse, I don't think lordships in exercise of power under 226 can interfere with that finding. Therefore, the end of the day, she is not even scheduled caste as on date. So because her caste certificate has been cancelled, which was issued by the Deputy Commissioner Kamrup Metro. Now, my lord, this aspect is also very relevant. I'll refer to one more judgment, my lord. So lordship should kindly have the judgment. 2005 to SCC 244. More or less, there are similarities of facts. I'll rely upon two paragraphs, my lord. 2005 to SCC 244, para 8 and para 10. Please come to page number 252.
Yes.
Elaborating her argument, learned counsel for the appellant contended that even though the appellant was born to Murahari Rao, a sis to Karnam, she was still being treated as a member of the Vagatha community to which her mother belonged, and that she had married a person belonging to Vagatha community. That Vagatha community had always accepted her as belonging to that committee. And in such a situation, she must be considered to be belonging to Vagatha community. A scheduled tribe and hence eligible to contest from a constituency reserved for the scheduled tribe. The appellant had married Appala Raju, her maternal uncle, belonging to Vagatha community, is not in dispute. Now, this is important. But the claim of the appellant that she was being brought up and was being recognized as a member belonging to Vagatha community cannot be accepted in the face of the evidence discussed by the High Court, including the documentary evidence relied on it by it. The document Exhibit 10 and the entry therein marked as Exhibit 11 relating to appellant show her caste as Sistu Karnam and not Vagatha. This entry was at an undisputed point of time. Moreover, the evidence also shows that she was always being educated at Visakhapatnam and she was never living as a tribal in Vimbaranam village to which her mother's family belonged. There is no reason for us to differ from the conclusion of the High Court on this aspect. Faced with this proposition, learned counsel for the appellant pitched her case on the fact that the appellant had married a person belonging to scheduled tribe and had thereby acquired the membership of the community, and consequently she must be treated as a member of the scheduled tribe. Learned counsel placed reliance on the decision of this court in so and so to contend that once a marriage of a male pertaining to scheduled tribe with a female pertaining to non-scheduled tribe was approved or sanctioned by the panchayat, they became member of the community. And even if the female is not a member of the tribe by virtue of birth, but she has been married to a tribal after due observance of all formalities and after obtaining the approval of the elders of the tribe, she would belong to the tribal community to which her husband belongs, on the analogy of wife taking the domicile of the husband. Learned counsel also referred to the decision in Valsama in support, though the said decision has been relied on by the High Court for negating the claim of the appellant in that regard. Then my lord will kindly come to para 10. What then remains is the fact that the appellant, though assigned by the caste of her father, Murahari Rao, namely the Sistu Karnam community, had married a tribal belonging to Vagatha community. On the basis of this marriage, it is argued that she must be taken to have acquired membership in the community of her husband and consequently treated as a member of that community. It is in that context that the decision in Horo was relied on. It is also contended that decision on Horo related to an election dispute and consequently the ratio of the decision should govern the present case. We have already indicated there is nothing to show that the marriage of appellant with Appala Raju was sanctioned or approved by the elders of the Bakata community or Panchayat concerned, or was in tribal form, or that the formalities attending such tribal marriage was observed and marriage was performed after obtaining approval of the elders of the tribe. Even otherwise, we have difficulty in accepting the position that non-tribal who marries a tribal could claim contest a seat reserved for tribal. Article 322 of the Constitution speaks of reservation of seats for scheduled tribes in legislative assemblies. Lordship may kindly skip this portion. If your Lordship will kindly come to Classitum F. The sentence starting with, the said reservation are also constitutional, has the Lordship got it? Milord?
Yes.
Yes. The said reservation are also constitutional reservation intending to benefit the really underprivileged and not those who to the class by way of marriage. To the extent the decision in Horo can be said to run counter to the above view, it cannot be accepted as correct. Even otherwise, in the absence of evidence on relevant aspect regarding marriage in tribal form and acceptance by the community, the decision in Horo cannot come to the rescue of the appellant. On a consideration of
Mr. Chaudhary,
Yes.
see, first, in this case, there is a voluntary marriage with a non-tribal, with a tribal. Secondly, if you see the facts involved, I read the judgment earlier. Facts involved. Here, the question was that this person, the father of the child, initially had a wife. And that wife, in spite, without giving a divorce, married and stayed with the second wife.
correct.
And they have been cohabiting together. The point which have been raised out there is that, look here, she was only a concubine. She was not the wife. And as such, this status has, therefore she was staying with the mother. That was the evidence which was looked into, and the High Court had categorically come to a finding that no, they were cohabiting together, and as such, they had the advantageous stage of the life.
So, my lord, here in this case also similarly, now if we, my lord,
I would have understood is the petitioner number 2, petitioner number 1, everybody residing with the grandparents of the the father or their father-in-law.
so, my lord,
The father-in-law bringing up the children.
no, my lord, that their claim that they have been brought up, yes, it's very unfortunate at the age of 6 and 2. Petitioner number 1 and 2 had to lose their father. A very unfortunate incident, my lord. It will not befall upon anybody, but that's a different aspect. Now the question is, what is the claim of the mother? Claim of the mother is, post my husband, who was a non-scheduled tribe, I have brought them up. Now, what is her duty? Because her husband was a non-scheduled tribe, therefore they'll have to establish few things, that they never had any advantageous start in life, which she failed, as per the report of the Milord State Level Scrutiny Committee based on evidence. What she could not establish was that she has initially.
No. The question of they had an advantage is the burden on them. Once there is an advantage, just for example, this woman, she had the advantages of living with her father, which was of the forward caste. She had the advantage. Then in case of Anjan, he had the advantages of living with his father. Later on, he went to his mother. The case of Balsama, this is a case where this woman concerned was all along brought up in the family of a forward caste. Then she married. And now, so there was an advantage of it. Once there is an advantage, then only the disadvantage will come.
No, but thereafter, while she was rearing the children, that there was no advantage where she has been able to prove. That she has to prove. If I have correctly understood the law, subject to correction. That's the requirement.
Advantages for what?
Let us see, my lord.
No,
Ramesh
no,
bhai.
Mr. Chaudhary, advantages for what?
My lord, so many things.
What?
My lord, here is a mother who,
What is
in
the
fact,
advantage?
she
No,
boasted
let us understand
that-
what is the advantages of being in the forward caste. Let
Lord-
us understand that
my
concept.
lord, lordship will kindly, it's a very peculiar case. If your lordship would kindly, he can report here, he will just mark it.
Let us not go by the Supreme Court,
No, no,
but by Mr. Chaudhary, tell me, what are the advantages of a forward caste?
My lord, advantage, my lord, she studied in convent educated schools.
Who?
See,
No, I'm not on that, but what
Huh?
is the advantages of a forward caste? Living in a forward caste.
my lord, end of the day, my lord, one of the basic characteristics of these backward classes are, they are very shy, my lord. They do not like to assimilate with the mainstream. That's why, my lord, they would like to go back so that they retain their primitive traits. So this is one of the most fundamental things. That is why they're not willing. My lord, I have seen in my own life, there's a place called Sosok. There was a time it was all inhabited by, my lord, original people of the state. Now, when people started purchasing land there because of coming up of dispute, what they did, my lord, they sold their land and they retreated to Sonapur. This is the correct time. This is what is required, my lord. Is this the case with the petitioners? Sorry, the petitioners of two, daughter and son. They have got best of everything in life. They were never born and brought up in that environment. Even if you are, my lord, scheduled, had it been a case where her father is not a scheduled, is a scheduled tribe, end of the matter, then this controversy would not have arisen. The fact that their father was a non-scheduled tribe, therefore all these complications have arisen. Now they are
So you
therefore
mean
the
to
law.
say because of the blood or the genes of the father? It's something like that.
That's the law.
That cannot be the law. As of now, I don't know if Supreme Court says tomorrow about that law that the blood and the genes of a forward caste
No,
would
no.
be the law.
Well, I'll not
I
go beyond
have-
para 55 of Ramesh.
Para 54 does not say that.
Para 55.
Para 54 says there has to be an advantages.
No.
Because of the advantage, there is no. Once you are born into a forward caste family and you have got some advantage, there has to be a disadvantage.
My lord, my humble submission is, Lord will kindly permit me to paste para 55 of Ramesh Bhai, is very clear. My lord. The law in my humble understanding is para 55, not para 40. In an intercaste marriage or marriage between a tribal and a non-tribal, there may be presumption the child takes the caste of the father. So moment there is an intercaste marriage, the normal presumption would be if the mother is scheduled tribe, the child will not be scheduled tribe. The child would be general, non-scheduled tribe. But that presumption is not irrebuttable, it's a rebuttable presumption. How that can be rebutted? This presumption may be stronger in case where the intercaste marriage between the tribal and non-tribal and the husband belongs to forward caste. But by no means the presumption is conclusive or irrebuttable, and it is open to the child of the marriage to lead evidence to show that she was brought up by the mother who belonged to the scheduled caste or scheduled tribe. By virtue of being a forward caste father, he did not have any advantage start in life, but on the contrary suffered deprivation, indignities, humilities, handicaps like any other member of the community to which her mother belonged. Additionally, that he always was treated as a member of the community to which her mother belonged, not only to the community, now this is important, but by the people outside the community as well. So, my lord, the requirement is not only they have to show all these things, it will also have to be shown that not only the community to which he belongs, that he is being treated as so and so, but he must also be treated by others. For example, there is an Assam case, Aurobindo Kumar Saha, it's a reported case, my lord, where he was a member of the Anusuchita Jati, and everybody regarded him as Anusuchita Jati. Therefore, my lord, the presumption was drawn. Now, here in this case, everything starts with that application which I have read, where she claims that her children were born and brought up in a scheduled tribe way. Therefore, the entire burden is upon her. Now, she failed to discharge the burden before the appropriate authority. Now, there are findings recorded.
So what is the Vigilance Commission report say? The report says that they inquired with the person concerned about the neighbor as to whether they suffered deprivation. Is that the yardstick on which you are to look into with the others? You are to see as to whether they recognize them as a scheduled tribe. Isn't it? If we go by that.
No, my lord, both. There,
to-
there are two requirements. One, that.
No,
resulting-
one, two, the first one they have proved it. There's no quarrel. But the second one
Yes.
would have been possible had they come up with the proper yardstick. That was not the yardstick on
In
which they
fact,
had
my
done.
lord, in this 2005 Supreme Court case, where High Court dealt with on the similar lines, and Supreme Court did not find any fault.
Let this matter also go to the Supreme Court. We'll see whether it finds fault or not.
Anyway, we'll make
And
our
how do
submission.
you take, because you see, Mr. Chaudhary, another thing. 1940, this judgment in Ramesh Bhai, in a sense said that Balsama judgment was wrong, in a sense that it has taken into account the judgment of 1943 Privy Council. At that point of time, the patriarchy system was very much prevalent.
Yes.
This is in 2000, was given in Valsama is in 2006. Then comes 2096. Valsama is 96.
Valsama 96 3 SCC.
Then comes 2011, na?
2005 is that Soha.
5 is okay. 5 did not go into that.
Yes.
But 2000, because the issue arose in Ramesh Bhai because that is it an unrebuttable presumption or it is a rebuttable presumption? There it therefore said that yes, it is a rebuttable presumption because if you see the issue involved is that can you say that it is an unrebuttable presumption? It said that no, it is a rebuttable presumption. It cannot be. And therefore it said out there that 1943 PB Council should not have been taken. This is in 2011. We are in 2024. And then when we have now the Supreme Court judgments out there as regards that, what is that? That on this army and all, where the woman has been now given a year. Now, let us take the question of a year. Because you see, the blood and the genes cannot be the basis. It has to be basis is on the whether they have been brought up in a backwardness. Backwardness, as I could understand from the various judgments is, or a person who is brought up in the forward caste, then, as you say, the shyness may not be there. You may find out then also there are some people, in an exception, the shyness is there. But here, in the backward caste, there are all these people who are, traditionally they are shy. So they don't want. But there might be, you will still find a lot of people out there who has become an election commission of India. You have the speaker of the legislative assembly. These people wouldn't be shy.
Including Chief
Then-
Justice of India.
So under such circumstances, are you going to say that these people are not entitled
No,
to?
no. It is only in case of an
Or
intercaste
their
marriage.
children are not entitled to? They would
that-
continue in view of
In case of
general.
natural born person, that principle will not apply. It is only in case of an intercaste marriage and the options of such intercaste marriage.
Can we just say on the basis of just because of the intercaste marriage, this will happen? It has to be mainly therefore, the word importance in the second condition is whether they had the advantage. If they had the advantage, which I could understand, let the Supreme Court test it, is as to whether it is a voluntary advantage or an involuntary advantage. If a person has an involuntary disadvantageous position, a person may, just in Anjan Kumar, he was all along brought up properly. Valsama, they were all brought up properly. And then they marry somebody because it is there. Maybe the father had pressurized them to get married. That's a different thing. But then they had all along the forward caste. They have been brought up in that particular society. Therefore, in judgment in Newell Irelo, the Chief Justice of India makes a very fine distinction to that effect. Then what will happen? He may be in a very good school, very good convent, but while going back home, he may still not get an answer which the other person may get it from his parents.
Possible. In a given case, it is possible. But can it be generalized?
No, it can't be. It cannot be generalized. So it has to be dependent on, therefore I'm saying the advantages has to be there. Now, if therefore, you recently, I was there, I was just thinking whether this analogy would apply. That the initial thing that there was an advantage has to be there in the vigilance report, that there was an advantage, and then the debate.
Which disappear. Lord, if your lordship will, I think lordship will rise. for
No,
that.
no, it's okay, I'm finishing it because then thereafter I have another. matter.
Yes, yes. If your lordship, they page 360, Manager.
And another thing,
Thank
you have earlier on referred to various, the mother writing a lot of letters out there that you see, I don't want my children to be
Yes,
scheduled tribe
yes,
and all
yes.
these things.
Ah.
But the fact is, isn't that the fundamental right of the children? Can it be waived by the mother? Can it be waived? A fundamental right cannot be waived.
Possessor, Supreme Court says it can't be.
Anyway, so whatever the mother does, it's a different thing. The mother may do.
No, but
There
the
might be, I
question-
am not suggesting that there is any case of a criminal implication as regard SC, ST or anything
Can I
against.
come in? I think to claim the status of a scheduled tribe, it may not be a fundamental right.
No. She says, she doesn't say it's about claim of a scheduled tribe. She says my children should not be getting any
what I'm
benefit
saying-
under 15.4
What I'm
or
saying-
16.
What I'm trying to submit.
That is what she said.
Right to claim a scheduled caste or a scheduled tribe status. Well, I don't think it's a fundamental right. It can be, it's a right which flows from
It
constitution.
is not a claim. You see, it is the claim, what she's saying.
No.
That I belong,
No, when we
my
say.
father was also an APS officer. I am a OPS. The third generation should not
No, what I-
get the benefits of
No, no.
reservation.
But what I'm trying to say is, my lord, when we say that one cannot waive his fundamental right, then we strictly confined to part 3. But status of a person as a tribe or a right to claim the status, my lord, these are constitutional rights, but these are not fundamental rights. Therefore, that principle subject to correction, my lord, may not apply strictly.
No, then we have to apply, can the mother say anything, waive the rights of the children?
That's an issue.
No, that is not relevant, therefore I am saying.
Yes.
Okay,
Yes,
then.
my lord, I'll not take very long. I'll just place 2-3 paragraphs. I'll conclude.
Which one?
Well, otherwise I have concluded. To sum up, my lord, if you also give me 2 minutes time, I can conclude.
Yes.
On my lord, locus, I have already made that submission. It depends upon the facts of each case. Here in the facts of the present case, I do have a locus. Yes, para 18 of my lord Ayub Khan Noor Khan, that is also a proposition of law. There can be.
Because
no question.
Ayub Khan, the problem which arose is there are twofold. Ayub Khan says that to challenge it, you have to either be a civil tribe or you are espousing the interest of those
That
who
class.
can. These are the two parameters when which it is.
It's something like as a stranger, you cannot just, meddle your battle.
So,
The busybody.
just for example,
Busybody interloper. Huh?
just for example, a person concerned who may otherwise would have been SC or ST, he can very well challenge, you see, because of them I'm being deprived.
Correct.
But can the general person go out there and say that
Here,
he cannot contest?
The contextual facts, my lord, since there is a adversarial sort of a litigation, therefore my submission is, I have a locus because my right was sought to be injured. Therefore, in the process of protecting myself, I'm questioning how come you are doing this because you do not belong to scheduled tribe. Number 1. Number 2, my lord, had it been a case where naturally born from ST and ST, mother and father, then this question would not have arisen. Now this question has arisen for the simple reason, the father is non-ST. Now it all started with that petition where she claims by virtue of Ramesh Bhai, ratio laid down in Ramesh Bhai, her son is entitled to certificate. Now therefore it was her onus. Now she tried to establish her onus before the competent authority, she failed. Now the authority rests its decision on tangible evidence. Now those evidence, unless it is perverse, I don't think a 226 court will interfere there. And my lord, nevertheless, the law is very clear. Not only they have to satisfy that these are the disadvantages. Others outside the community also must regard them that she belongs to this category, as was done in that Assam case. So until and unless these conditions are satisfied, children of an intercaste marriage cannot pray for the caste of the mother or father as the case may be. So that being the position in my humble submission, my lord. The state level committee has acted on cosette materials, and I don't think there is any perversity.
No, the order will go. There's no quarrel with that. The order will go. I'm saying, thinking on the yardstick, because you see on natural justice is absolutely in violation. You cannot. There you cannot.
Anyway, my lord,
There
have done our
order
duty,
will
we will
go,
not-
but on that aspect I was hearing, because the only thing therefore I was just thinking, should I touch this or not, the locus? Because that is another judgment which will come in later on.
May I say? What your lordship is proposing, perhaps, Lucas may not be that relevant in the.
No,
process.
I may not, because I may have to say because of the division bench judgment. Because of the division bench, I cannot go there. But overall, the means I will observe that that is not the thing, but in this case I cannot.
And my lord, para 48 of Ramesh Bhai, in my humble submission, is not the ratio of the decision. That was an observation made. Rather, the Honorable Supreme Court posed a question to itself, but that question was never answered.
What is that? Paragraph
That
14?
supposing, my lord, if a general category, person, sorry, scheduled tribe is married to a general category man, then my lord, post-marriage, or maybe when the child was in the womb, there's a divorce or separation.
Yeah, the
When-
Supreme Court did not raise it. You see, that was the question which was raised in that full bench judgment in Kerala.
Bombay High Court.
No, Kerala. That is a
Oh,
Kerala.
Kerala,
judgment.
Kerala.
That is a Kerala judgment. I've seen it in the Kerala full bench judgment. This was raised in the Kerala full bench judgment.
And then, my lord,
Lordship, you don't want to hear me on locus.
No, what is there? You have
Lordship, in all fairness, it was oversight. We have not raised it. And we are very grateful to your Lordship for raising it because it is an important issue, devoid of facts of this case. Under the Scheduled Tribe Act, the jurisdictional fact is that you have to be a scheduled tribe. Undoubted. Is caste certificate the only way to prove it? No. But you have to prove that you are, the offense is that you've committed knowing that I am a scheduled caste. That is the jurisdictional fact. He is claiming locus in my social status. At the end of it, this is a fight for my social status. Supposing there was no schedule, I had not invoked that. Does he have locus? Issue is that if I had not invoked the SCST Act, that is Ayub Khan. Regarding my social status, who has locus to go before the caste committee or file a writ challenging my social status? Ayub Khan takes two situations. One situation is when there is a non-scheduled caste third party. Can you come? Do you have locus? He says, no, except in exceptional circumstances, subject to public interest and you not having, the guy who's claiming locus sender, not having any personal gain or any personal axe to grind. On that ground itself, he's out because he's clearly personally interested in my social status. But for
Because in Ayub Khan in paragraph 21, where
Correct,
they
Your
were
Lordship.
referring to Baldev Singh.
yes, Your Lordship. So in paragraph 23, he's not covered because he has a personal axe to grind. He wants to protect himself from being prosecuted. So clearly, he is not that third party. Now we come back to traditional notions of locus. What is the traditional? And Ayub Khan deals with it. And it says, Lordship, you have to have a legal right. Paragraph 18 itself and the Moir case. Because I am on locus regarding my social status. Not the division bench gave him locus in an investigation because he
When you
challenged.
come to paragraph 21, they are referring to Balbir Singh.
Yes, Your Lordship.
There you see paragraph 45. We must now deal with the question of locus. A special leave petition ordinarily would not have been entertained at the instance of the appellant.
Yes, Your Lordship.
Validity of the appointment or otherwise is on the basis of a caste certificate granted by committee is ordinarily a matter between the employer and employee. This court, however, when a question is raised, can take cognizance of a matter of such grave importance as suo motu. It may not treat the special leave petition as a public interest but as a public law litigation. It is in the proceeding of that nature permissible for the court to make a detailed inquiry with regard to the broader aspects of the matter, although it was initiated at the instance of a a person having private interest. A deeper scrutiny can be made so as to enable the court to find out as to whether a party to a list is guilty of a commission of a fraud on the constitution. If such an inquiry subserves the greater public interest and has far-reaching effect on the society, in our opinion, this court will not shrink area. Even in cases of public interest, the court can exercise jurisdiction at the instance of a third party only when it is shown that the legal wrong or legal injury or illegal burden is threatened and such person or determined class of person is by reason of poverty, helplessness or disability or socially or economically backwards advantage unable to approach. Thus, from the above, it is evident that under ordinary circumstances, a third person having no concern with the case at hand cannot claim to have any local standard to raise any grievance whatsoever. However, in exceptional circumstances as referred to above, if the actual person agrees because of ignorance, illiteracy, inarticulation, or poverty, so and so, then the court may examine the issue and in exceptional circumstances, even if broader bona fides are doubted here. So this the court can.
Yes, Your Lordship.
This court can look into it.
Yes,
Just
Your
for example, an issue has been raised by them, but this court
Yes, Your
may take into account that whether, because here another issue is that this would amount to a deprivation to others who comes within the ambit of 16.4 or 15.4. This court
So,
can look into it. But
That's a
can there
public
be an
interest.
initiation?
That's a public interest in it.
Now,
Now, here
can
is
there be an
something-
initiation?
He disqualifies himself under paragraph 23 according to my submission because it says has no personal agenda or object in relation to which he can grind his own acts. So he's disqualified in this. So this is very much his own case that he's espousing and he's challenging my social status. Now I take it on legal injury. He's claiming legal injury. What is the legal injury? Prosecution. The legal injury has to be premised on a legal right. So at the end, to establish that he is injured, he has to establish that he has a right to molest children under the SC/ST Act. Lordship, it is that. It is only that. Because,
Yes, to-
Lordship, that every prosecution.
Far-fetched.
No, Lordship.
Anyways, I didn't have to hear you. Okay, hearing completed, judgment. You'll get it on Monday. Judgment is on Monday.
Deep problem.
My lord, here item number 20 and item number 27 are wrongly tagged, my lord. They're not similar. Item number 20 and 27 are wrongly tagged, my lord, inadvertently tagged, my lord.
What are those?
And these are separate issues, my lord, not regarding the notice 57. This is not regarding notification 56, my lord. Separate issues, my lord.
Yeah, did you make that?
Yes, Your Lordship. Lordship, in the chart, I have excluded the matters which a learned friend has said that it is not covered under the 20 and 27.
Which is not covered?
20 and 27, Lordship, I have not given,
Item 20 and 27, madam.
I have not given the list.
So all these cases,
5623, Lordship. All are 5623.
then why should I touch 9?
Did it. All are 5623. I have verified for each and every reader, 5623.
There's no reason for touching 9.
In fact, I made it very on the last day that if I quash 5623, what implications will it have on the proposals of the Finance Act 2024? Or if Lordship touches 9, it might have implications on the proposals of Finance Act.
Huh?
If your Lordship touches 9 of the 23, it might have severe consequences for the proposals in Finance Act 2024. Lordship. Because the petitioners might get deprived of the benefits.
Might have?
Might get deprived from the benefits of the Finance Act 2024, Lordship. If your Lordship touches 9.
No, 9 I'm going to uphold it.
But these are not subject matter in these petitions.
So therefore, why should I take up 9?
Yes, Your Lordship.
My lord, one more thing, my lord. In item number, my lord, 21, my lord, which is defect in the prayer portion, my lord.
What is that?
Lord, I have challenged the consequential order, but inadvertently my challenge to notification 56 not there, my lord. So I may be allowed to withdraw with liberty to file a fresh. I have noticed in the morning only, my lord. Today morning I have noticed it, my lord. Item 21. Otherwise, it will be covered by lordship's order, my lord.
Or I may be-
The 21, I think better. We'll pass a separate order,
Right.
21 separately, huh?
Right.
Because of the fact that 21 is out. What is the name of the case? Pankaj Karnikar.
Oh, yes, but Pankaj Kanika, my lord.
I've heard the learned counsels appearing on behalf of the parties and have duly given my anxious consideration. This court have duly taken note of the impugn orders in origin, which have been also challenged, which are challenged in the instant batch of petitions. And from a perusal of the said impugned orders in originals, it is seen that these orders have been passed in respect to the financial year 2018-19. And after, on or after 1/4/2024. Under such circumstances, the challenge so made in respect to the notifications, number 9/2023 CT, as well as the parameterial notification issued by the state government dated 6/9/2024, has no relevance. Therefore, the question which arises, which is required to be adjudicated upon, is as to whether the notification number 56 of late 2023 CT dated 28/12/2023 is in consonant, is ultra-virus the provisions of section 168A of both the State Act as well as the Central Act. In the preceding sections of the instant judgment, this court have duly had quoted, had reproduced the provisions of section 168A which is parameterial in content in both the State and the Central Act. This court have also dealt with the 4 conditions which are required to be had also dealt with as to when the provisions of section 168A could be invoked. That is, number 1, on the recommendation made by the GST Council. Number 2, by issuance of a notification to extend the time limit specified or prescribed or notified under the Central Act or the State Act as the case may be. Number 3, in respect of actions which cannot be completed or complied. And number 4, due to force majeure. Or in other words, the force majeure has to be in relation to actions which cannot be completed or complied. It will also be seen from the explanation to section 168A that the expression force majeure has been defined as a case of war, epidemic, flood, drought, fire, cyclone, earthquake, or any other calamity caused by nature or otherwise affecting the implementation of any of the provisions of the Act. Therefore, The implementation of the act has to be construed to be in respect to those actions which cannot be completed or complied with on account of happening of the events as defined in the explanation to section 168A of the act. In the case of Dhanraj Jamal Govindra versus Samiji Kalidas and Co. reported in AIR 1961 SC 1285. His Lordships M. Hidayatullah, bracket as his Lordship then was, dealt with the concept of force measure and observed that difficulties and observed that the said term would imply difficulties which had arisen and observed has observed that where reference is made to the term force measure, the intention is to save the performing party from the control of anything over which he has no control. Therefore, the question Therefore, in the context of section 168A bracket 1, the power can be exercised by the government in respect of actions which cannot be completed or complied with by the functionaries under the central or the state act, as it is beyond their control. It is also seen, it is very pertinent also to take note of as to when the power can be exercised under section 168A(1). Inasmuch as can be exercised by the government. The same power can be exercised on the recommendation of the GST Council. The use of the words on the recommendation of the council signified that there has to be a recommendation on the basis of which the government could exercise the power. At this stage, if this court takes note of the judgment of the Supreme Court in the case of Mohit Minerals Supra, the issue involved therein was that the central government had issued a notification number 10/2017 wherein at serial number 10 of the said notification, the recipient of the services of supply of goods by a person in a non-taxable territory by a vessel to be included as an importer under section 226 of the Customs Act. Categorize the recipient of service of supply of goods by a person in a non-taxable territory by a vessel to include an importer under section 226 of the Customs Act 1962. This notification was put to challenge. On the ground as to whether an Indian importer can be subject to levy of integrated goods and service tax on the component of ocean freight paid by the foreign seller to a foreign shipping line on a reverse charge basis. The same notification to 10 already, 8th of 2017. The same notification was issued in exercise of the power under section 51, 61 and 20 Roman 3-Roman 4 of the Integrated Goods and Service Tax Act 2017, read with sections 15.5 and 16.1 of the Central Act, with the on the advice of the GST Council. It is seen that the High Court of Gujarat, Gujarat High Court, by the judgment and order dated 23/1/2020, had set aside these notifications. The appeal which was filed by the Union of India, an appeal was filed before was filed by the Union of India, wherein amongst various contentions, it was submitted by the learned Attorney General that the GST Council is empowered to decide on every aspect of the GST law, and the recommendation of the GST Council are binding on the executive and the legislature while it frames laws relating to the GST by the power under Article 246A. It was also submitted that though Article 246A did not subject Article 246A to Article 279A, the Union and the states, after exercising their legislative power and discretion under Article 246A1, have agreed to go by the recommendation of the GST Council in every aspect of the GST law, wherever required. In the spirit of collaborative federalism, which must be respected by upholding the constitutional validity of the impugned notifications. It is in that context the Supreme Court had dealt with the aspect as to how far the recommendations so made by the GST Council was binding on the union or the state. In paragraph number 59 of the said judgment, the Supreme Court observed that the GST Council had plenary powers under Article 279A bracket 4 bracket H, where it could make recommendation on inverted comma any other matter related to GST as the council may decide. And this recommendation and to arrive at such, to make such recommendations, the GST Council has to process it through a harmonized deliberation between the federal units as provided in clause 6 of Article 279A. The Supreme Court observed in the said judgment that the recommendations so made in spite of there being provisions in the IGST Act and the Central Act, must be interpreted with reference to the purpose of the enactment. Which is to create a uniform taxation system. The Supreme Court though observed that the recommendation of the GST Council are made binding on the government when it exercises its power to notify secondary legislations to give effect to the uniform taxation system. But that would not mean that all of the GST Council's recommendations are binding. In as much as Article 279A of the Constitution only stipulates that the GST Council can make recommendations and the value of such recommendation have not been explained in the Constitution. It was therefore observed that the GST Act, that the Central Act or the State Act or even the IGST Act cannot make those recommendations binding if the Parliament or the state legislature had the power under Article 246A of the Constitution the Supreme Court further explained the same respect in paragraph number 171 of the said judgment. The relevant paragraphs, paragraph 171.1, 171.1.1 to paragraph 171.1.3 being relevant is reproduced here in under. In the backdrop of the above, the above aspect had to be touched. taking into account the second affidavits in opposition so filed by the CGST, wherein the statement was made, wherein a stand was taken that the recommendations of the GST Council was not binding, and were only persuasive in nature. The said stand, in the opinion of this court, could not have been applied in the context of the instant case. Taking into account that the Supreme Court, taking into account that for the purpose of the notification number 56 of 2023 CT, there is no recommendation at all apart from that. It is also pertinent to mention that the notification which is to be issued under section 168A is a secondary piece of legislation which does not touch on the power under 246A of the state legislature or the parliament. And under such circumstances, even in view of the judgment in the case of Mohit Minerals Supra, the recommendations so made by the GST Council would be binding on the union and as well as the state government. This court further, in the following paragraphs of the instant judgment, this court had categorically dealt with that the notification number 56 of 2023 CT states that the same notification has been issued with the recommendation of the council, which in fact is not correct, taking into account that it is an admitted position in the affidavit so filed, as well as the circular dated 14/5/2024, that the same notification was issued without the notification without the recommendation of the GST Council. Under such circumstances, as the said notification has been issued, as the said notifications dated 56/2023 CE have been issued without the recommendation of the GST Council. The said notification is ultra vires, both under the Central Act and accordingly liable to be interfered with. It is also very pertinent to mention that the state of Assam have not issued a parameter notification for the period beyond 1/4/2023 for the financial year 2018 and 19. And as such, the impugn orders which have been passed under section 73(9), both under the Central Act as well as State Act, are bad in law. Are without jurisdiction in view of the setting aside and quashing of the notification number 56/2023 CE CT dated so and so. The details of the details, the respective impugn orders or the impugn orders in origins in respect to the which have been put to challenge in the instant writ petition, instant batch of writ petitions, are given in an appendix to the instant judgment. And are set aside and quashed. The details of the said impugn orders in origins are given in an appendix to the instant judgment. With the above, the instant petitions stands allowed.
What is date of Assam? Only April, that month of April 24, it has not been notified in parameter 56. In March 24, it is there. Persuade said it 2023. In March 24, it is there.
No. I would say 1/4/2024.
It is 23, it should be 24.
No, that I'll correct it. Don't worry. No, these will be corrected. Don't worry. These are only. But you have not done it properly. You should have categorically given in petition number so and so for the financial year. What is this assessment year? Do you have an assessment year in the
Financial.
CGST?
Financial.
Why? This is not done.
Should I change it
No, this is not very properly done.
in the lunchtime?
No, you should have done it properly. You should have said the order of original dated bearing number so and so, because that has to be set aside. You are not mentioning what order dated.
Yes, sir.
Passed by whom? Order in original dated the bearing number so and so. In WPC number, the appendix, you have to give like this appendix. In WPC number 3585/2024, the order in original put to challenge being so and so. Bearing number so and so, is dated so and so, for the financial year so and so, passed by so and so, is set aside. Like that, everywhere. It can't be like this. This is not. So 56 we have not, 9 we have not touched. The last line to likhi dibo. Before parting with the record, the learned counsel appearing on behalf of both the CGST and the SGST submits that the state government has the power, both the state as union government as well as the state government has the power in terms of section 168A to make retrospective, to issue retrospective notifications. And the judgment so passed herein should not prejudice the state right. So this court, it is relevant to mention herein that this court have set aside the instant judgment, the orders in original referred to, detailed out there in the appendix on the basis of the notification number 56/2023 being so and so, being ultra-virus, the provisions of section 168A of the Central Act, as well as there being no notification issued in respect to the state act by the state government under section, in conformity with section 168A of the state act. The power, under such circumstances, the decision herein shall not preclude the state as well as the union or the central government to act, to take such action as envisaged under the provisions. Okay. But they may come, then again you come.
Item number 32, my lord. Item 32, my lord. It pertains to financial year 1920, my lord. It is 32.
That
Yes.
chart I will,
In that chart will give, my lord. In the chart will give item 32, my lord.
the appendix.
It pertains to financial year 1920, my lord.
It was mentioned some dates in the order as regards financial year 18-19. So Lordship will have to add some dates related to 1920.
Yes, yes, give me the appendix properly, otherwise you don't get the judgment.
Lordship,
No, you can do it, but you have to get that, which you have not. And I'll refer to about that notification in the GST, it has not been taken. This I'll just put it, not there. I'll put it, that you have not placed it in the other meetings of 50, 51, 52. That I'll.
Lordship, one more thing was there. Lordship, everywhere where it is written CE, it will be CT. Because Lordship, CE refers to central act, central excise.
CT.
CT, it will be CT everywhere.
And one more thing, I just remembered. Yesterday, that interim order which I passed in that case, I will put it in this manner that this 10% you need not pay, subject to there 10% of the amount is lying in that account.
Yes, your Lordship.
One. Secondly, if you get a stay and the freezing is removed, then you have to deposit.
Yes, your Lordship. That is also.
That these are the two conditions which I'll put it, because otherwise tomorrow if you have just 1 lakh, you have already, because here is a case, it's a case of recovery of the ITC which you have been paid to you, which is a different aspect from the other aspect. So that I'll put it, Mr. Gogoi. That then I think your thing will be safe. Then what happens if he has, if it is 1 crore, na?
Yes.
It will be 1 crore or something.
The total demand is 3 crores, but the 10% will come to 20 lakhs.
20 lakhs. Now, if he has just for example, 5 lakhs out there. That cannot be done. So then they have to pay you another 15 lakhs at the time of it. But if they have the 20 lakhs, then need not. That is. Huh? And the moment they get a stay, then and the freezing is removed, then they'll have to do.
So we fine, one report, my lord. and-
This categorically says there is nothing, there is no. Are we to understand that you have given a false statement before the division bench? Then how did this happen? Here with Kamru.
Yes. This is one another report, my lord, which is a part of that, my lord, PIL. This is the extract, my lord. There lordship will find, my lord, down below, my lord, at serial number 3.
Serial number?
Serial number 3, my lord, in the just one page table which I have just now given, there lordship will kindly come, my lord, to the serial number 3, name of the district, Kamrup Metro,
We are not Kamrup Metro or Kamrup district, yeah.
Kamrup Metro.
No, this is
First under
Kamrup.
Kamrup Metro.
Okay, Kamrup Metro.
Kamrup Metro, then total population, lordship will kindly come, my lord, to the last column. Land under encroachment in tribal belt and block. 1,800.
We are concerned with Kamrup Metro.
Yes,
This-
yes, yes.
Come with-
That area is under metro.
Kamrup Metro.
1861.
1861, with
So
Bihar.
this is there also here. In Kamrup Metro, Kamrup rural, there is no.
Yes.
There is no encroachment.
Now we are concerned with that, but fact remains, my lord, that because if you go by the legal parameters, then definitely, my lord, prior to 1950, my lord, they will be protected. And they will have an opportunity, my lord, let them file a representation, my lord, individual representation before the deputy.
What are you doing against these people? This is a 2019 order. What is the latest order in this package?
That case, my lord, one order I have, my lord, whereby,
We
my
are
lord,
going into this old
Yes.
year. This is 5 years old. What is the latest order?
Pending.
pending, my lord, one order, my lord, it is of dated 3/6/2024.
Give us of this present Chief Justice or the earlier one, or the earlier one. This is of the earlier to earlier one.
That I have, my lord, my lord, produced before this honorable court, my lord, to bring home the contention that, my lord, we have depicted the entire picture of, my lord, for the entire state of Assam. So, my lord, where and in which place, my lord, tribal lands, my lord, lands falling under the tribal belt and blocks have been enforced upon, my lord, with full facts and figures.
Because in these matters, the recent matters, what has happened, all these repetitions which were tagged have been detached.
Because some person has come, my lord, they are also protecting. They say, my lord, we should not be evicted. But the fact remains, my lord, that in the PIL, the honorable division bench is exercising the jurisdiction of issuing rate of continuing mandamus. There were
Understood.
direction have been issued.
But the force seems to have lessened down.
But here, my lord, the only precise issue will be, my lord, whether they come within, if they come, my lord, post 1950 or prior to 1950. If prior to 1950.
But for that, why you are not issuing a notice to them? Why you are not issuing a notice to them, asking him to explain why you are passing this order the way which you?
Eviction has been passed, my lord, because recently, my lord, there has been a sudden inflow, my lord, of persons.
These people have been there all this while.
Not for these people, my lord.
Then
There are other.
you have given this. What is this? See your notice, what you are saying. This is a general notice given to everybody.
Yes, my lord.
As enclosed above, Miyadi Patta number 1 to 200, Exonia Patta 1 to 87. What is this type of area? Where, which place? Nothing.
the pattas have been
of
identified.
the land schedule belonging to the Katsoli Pothar Revenue Village under Sonapur annexed with this notice is and are directed to vacate within 3 days. It can't happen like this. You can't do this without a notice. You have to give a proper notice, asking them, these people have been there. Why should this court again incorporate the principles of natural justice? You should have issued them the notice that look here, kindly produce your document. These people are not there. I would have understood just a trespasser, you just throw them up, they have entered. But these people, and why you are not issuing the notice to everybody who are there? Why you are not
Individual,
issuing the notice to everybody?
So, my lordship,
How will they know? Just for example, I'm telling you, where is this notice pasted?
Lord, in some
Yes, they have
confiscated
just
places.
pasted it in some conspicuous place. Now, this notice, if you are pasting it on the conspicuous place, then very well, how will a person know? How will the person reply? There, how will a person show that look here, I've been here from 1950?
so
Why do you need this intervention of the court for passing an order?
So therefore, my lord, now these are the materials before lordship. I have placed that order. So if lordship is pleased to take up these matters tomorrow, learned advocate general will appear. Until then, my lord, till tomorrow, my lord, I have the under instructions of advocate general and giving an assurance to this honorable court that till tomorrow, my lord, nothing is going to happen. And more particularly, my lord, against those persons. Now, lordship will kindly appreciate one aspect of the
No,
matter.
first of all, don't do anything as regards this notice at all. You can't do this. How is it? You just paste it somewhere.
So, my lord,
We are at a time, this rule, what power you have exercised this, let's see. 1866. Can't do this. In case of unsettled land, any person who without authority has encroached upon or occupied it shall be ejected forthwith. In the case of annually settled land, persons other than settlement holders, members of their families and hiree found in occupation shall be liable to a year forthwith. The settlement holder shall unless terminated earlier for infringement of the conditions of lease so and so. In the case of periodically settled land, persons who have entered into occupation without valid authority from the landholder or whose entry or occupation is or has come about in a manner inconsistent with the provisions of the act shall be liable for eviction. In the case of such eviction shall be preceded by service of notice requiring the occupants to vacate the land and remove all buildings and other constructions. The deputy commissioner may, after the persons have vacated or have evicted from the land, take the land under their own management or may let inform for such person period as he may think, but shall give the landholders a reasonable opportunity of undertaking in writing that he will do so. Now, how do you take care of 3B, 3A?
in case of periodically settled land, persons who have entered into occupation without valid authority from the landholder or whose entry or occupation is or has come about in a manner inconsistent with the provisions of this chapter shall be liable to eviction.
Then thereafter,
Yes, such eviction shall be preceded by service of notice requiring the occupants to vacate the land and to remove all buildings and other constructions erected and crops raised within a period not exceeding 1 month from the date of receipt of the notice.
then
Deputy Commissioner may, after the persons have vacated or have been evicted from the land, take the land under his own management or may let in firm for such period as he thinks fit, but shall give the landholders a reasonable opportunity of undertaking in writing that he will do everything in this power to prevent unauthorized occupation by other persons in future and of agreeing in writing that on his failure to do so, he will forfeit his rights and status of a landholder in respect of the land. If satisfied with an undertaking, an agreement as aforesaid, the deputy commissioner shall accept them and they shall be deemed to govern the landholder's future rights and status in respect of the land, and the land shall then be restored to the landholder. If the landholder subsequently contravenes the undertaking as aforesaid, or any of provisions of section 9, he shall be liable to forfeiture of his rights and status in respect of the land, which will then be available for settlement
So
afresh.
as per 165, there are three things. First, those people who have no authority.
Yes,
Second, annually settled.
yes,
Third, periodically settled.
periodically settled.
When periodically settled, it categorically says that there is a question of notice. What is this type of notice you are issuing? And that to that person, what is this type of notice?
But otherwise also, my lord, now these notices issued, they have put this notice to challenge. Now, if the authorities come and sought to evict them, I'm making a submission, then they will have every opportunity to, my lord, to, my lord, place before the authority that, look, these are my documents.
But there is
Otherwise-
no notice issued to them, and these are respective notices. This can't be a notice, because here it says, such as shall be preceded by service requiring the occupants. So there has to be service of notice upon them.
There has to be individual notices issued to.
Can't
No,
like
no,
happen like this.
No, but that is only pertaining to, my lord, who are holding periodic patta. Who are holding periodic.
They say that they are holding, that is what the documents say.
Therefore, but my lord, then again the issue will arise, my lord. How come they came into occupation? Now,
So when you give a notice, they will reply. But where is your notice? You are asking them to vacate within 3 days. You can't do that.
Lordship may be pleased to hear this matter tomorrow, my lord, in presence of the Advocate General, my lord. Till tomorrow, my lord, because that is the clear instruction, my lord. Now, my lord, those persons who have been able to show, my lord, because they are not the petitioners. On instruction, I am making this statement. My lord, at the time of eviction, my lord, several persons, many persons, they have shown, my lord, that they, my lord, have come into occupation prior to, my lord, 1950, my lord. My lord, for them, my lord, perhaps eviction has not proceeded.
Whatever may be, but why it is this pick and choose to somebody you have got it and somebody not?
No, it is not a matter of pick and choose, because this is a general notice. Lordship will kindly appreciate.
Understood.
It-
Where is the concept of a general notice on 165?
Therefore, there is no pick and choose. Lord.
No. How did some person go and show that, okay, 1950, I am there? Why did he show? Here, there is no opportunity. Kindly show us any document. I would have understood. You conduct a hearing and pass thereafter, issue notice, hearing everybody out there and then pass an order. It can't be on the basis that in 2019, the division bench passes an order that these are the time, kindly do and enforce out there, and because of that, you keep on doing it. I understand the predicament of the state government to follow the directions of the division bench in that sumo to PL. But then also, one has to then also look into the provisions of law, natural justice. Something has to be there. These are sacrosanct things.
Till tomorrow, my lord. Because
Tomorrow
now,
you don't do it. Only thing is that if I entertain the matter, I'll stay. So take a decision on that. You issue them fresh notice, proper notice, and then evict them.
first appropriate orders in presence of the Advocate General, because
yes.
he will be in a
Because
better
if
position.
you contest, I'll have a hearing on this, whether it is possible or not. Because these are questions which this court can't look into it. How much is the person? How many DHRA? It is for you. But it could have been done very properly, not at the this
Okay.
force of air.
Therefore, I have made an attempt, my lord, to persuade your lordship, my lord, with some pieces of papers, my lord, which I
Yeah,
have
Advocate General,
collected, my lord.
list this matter on tomorrow. Pusto. Mr. Arma Pujari appearing on behalf of the Revenue Department. And also under the instructions from the Advocate General had submitted that no course of action should be taken in pursuant to the notice dated 13/9/2024 issued by the Circle Officer, Sonapur Revenue Circle in tomorrow.
Applies.
And so, like,
Next item is also same.
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 same, my lord. There are 10 to 11 petitioners in both the matters, my lord, each, my lord.
But the thing is that one has to,
No, Lordship is correct, my lord. because
my judgment in that Salakuddin is therefore, it is in fact helpful for the state because it becomes now very easy. You should not do whatever you like. I have nothing to do. But if you don't do that, basic principles has to be followed. What is this?
Similar matter, similar cause of action. I mean, I'm under 3A. I have a periodic patta. My father had the periodic patta in 1960 and periodic
19?
patta 1960.
and the
Before
Before that, I have annual patta, conversion of annual patta to periodic patta.
annual patta when?
Annual patta was the same period of 20s, 1920s. Well, and also my question herein was that on the point that your lordship has raised regarding the notice, a further obligation is cast under notice for the set landholder to undertake before the government that he will evict the trespassers and not allow them to re-enter the land. So there is a second step required where the restoration of possession is given back to the landholder. And if that is violated, then only the land is forfeit. Well, that step they have completely omitted. That is missing.
Huh?
That step they have completely omitted. The deputy commissioner giving a notice, obtaining an undertaking from the landholder that these trespassers are to be evicted and no further trespassing is to be permitted in under circumstances.
Because 165, as you say rightly, is for the benefit of those people, these are ST.
These are not ST, these are non-protected classes.
No, no, tribal belt.
Yes, yes. The entire chapter is for benefit of ST. Yes.
The tribal belt should be given to those ST or what? Tribal belts is to whom?
Tribal belts, my lord, to the scheduled tribes.
There are six.
Only ST.
Well, there are six.
And
classes.
if they are not, means it is only under that
They have-
342,
They have to be notified tribals.
then only they get it. And just for example, a Chakma would not get it.
You know,
Gazette notification.
There has to be a
notifying them
notified.
protected class.
protected class has to be protected.
That notification is required to be made. I mean, if my learned friend can bring on record that which class has been not gazette notified, that
That is not the list. That is not his list. Why should I be burdened? That is not the list.
There are
Have you issued or not that notification?
There are six
That
classes.
is not
madam.
the list, my lord.
There
It
were
is but-
six classes initially issued of the tribal people, different categories. Nepalese grazers were included therein. They were removed in 1990, thereafter reinserted again. So there are six. There is a notification. I do not have it, but it is in 1960s only issued a notification. Six particular protected classes.
Now, in. all the-
Okay, it will okay. We'll have it on that day, tomorrow.
Only
Huh?
with regard to my lord, this matter, my lord, this production item not able to keep the maintainability open, my lord. This repetition. Prima facie, my lord, there are no materials to suggest, my lord, that they had, my lord, the genealogical link, my lord, prior to 1950. The first document, annexer
We
one.
will take it on.
Yes.
You want to argue, I can very well argue, take up all the matters you want to.
Tomorrow,
No. The protection remains to all these three cases.
the protection will remain, but so far as, my lord, this case is concerned, because here,
We
my
will
lord,
look into that on that date. But how do you take care of 165 3A?
I'm obliged.
So here the notification gives it to only to the backward classes. So
That was also not put on the challenge.
yes.
Paper
Oh yes, what has happened?
Senior is less.
You don't have a case.
The thing is, my senior is on decks, but what I've been, what I've been, I don't understand, the clause regarding MSME, that has not been put on the challenge. You'll also see the prayer question.
But what to do? There's a division, coordinate bench judgment. I'm bound by that. I've made it very clear to your senior on the
yes,
last occasion as to whether there is any way out. Nothing. You also said that that particular, there is one line out there. That line does not.
Your Lordship, would kindly allow us to bring on record that particular tender over which this challenge was made by Plaban Trade Agency, that particular judgment of Justice Jayan. That tender, particular tender, your Lordship allows us to bring.
Why should I allow you? It
Because
is
that,
for
that
you
way
to
we
come.
can compare the current clauses of the instant tender in this matter and that particular. What sets them apart? Then it will be perhaps easier for this court also matter. And also in another way, it might help us if there's some difference. Just one opportunity because this came up. That's why.
No, I will follow Justice Bhuya's order. You have not challenged that order, but you can challenge
That
this
is fine.
order and take it up before the division bench. The division bench may say that Justice Bhuya's order is bad and for which my order will go. Let it go. But then also, but see, I'm tied. Problem arises, although I don't accept, means I don't agree what has been stated, but there's no good
the
ground
knowledge
for
law, I
me
understand.
to.
Always there. That's correct. And that remained unchallenged.
So and that remain unchallenged, and there's no good ground for me to defer. So this judgment, unless you show something else by here where I can say that it is a per incurium judgment, it's a different thing. But it's very difficult in this case to do that.
That is what is left with us now, just to have a comparison between both these tenders, the instant tender and that particular tender.
No,
Why
the
not keep
thing
it
is
partner?
that I'll pass an order following that judgment. You file an appeal and get it set aside. My order, then the question is that you could have very well, then you can very well raise the point that Justice Muir's order is not right. It was on those facts and all, you get it settled. But for me to set aside, go not to follow the judgment becomes very difficult.
But that tender will not be on record. My lord. I'm not saying I'm going to file an affidavit. It's- My lord allows me to just bring that tender and place it before the court of definite. And lordship will keep this part.
It is already part of.
My lord.
It is there to keep part of.
We will have it on in our record.
You see, why I'm saying it here, if you see Justice Muir's order,
Yes, that
he
particular. paragraph.
categorically takes note of that, yeah, in terms of that.
That's why over the time, what changed actually? Is there any difference between that particular clause of that?
Because what he says out here, in the instant case, what the response number 1 and 2 have done is that since respondent was placed the serial number 1 under the MSME category and he has offered 5 trucks, they straight away allotted 5 tank trucks to respond number 3. Full stop. 5 tank trucks offered by respondent certainly made respond number 3 eligible, and by virtue of offering a large number of vehicles, that too owned it, and it was rightly placed at serial number 1. So also respond number 4 was rightly placed with so and so, is to encourage so and so. As noticed, the allotment has to be made to those tenderers who offered minimum 3 tanks, out of which a minimum of 1 truck should be owned by the area and the other so and so. And it is this context that the expression proportionate would be 1 tank truck each for shortlisted bidders, since shortlisted bidders were more than 6, which would be in tune with the objective of the 2006 Act. If this was done, petitioner would have got allotment of 1 truck, which would be in tune with the proportionate reservation policy allotting 5 tank trucks to serial number 1 and remaining 1 tank truck to serial number 2 to the exclusion of other so and so up to the maximum limit of 6 would not be in the true spirit of the reservation of the. The problem arises with this. When this is being mentioned, would have the true spirit. Because he was deciding on the question of the MSME Act also. Yes, Mr. Chaudhary. Did you get anything? How I can say that the judgment is foreign for you? I am therefore suggesting your junior, I'll pass the judgment following that. You file appeal, challenge it, and thereby challenging it, the division bench can do anything.
In fact, perhaps Malad, your lordship can also take a different view.
You see, my view is different. My view is very, particularly the thing that it should be absolutely, you should have you being the, you should always have the that, okay, these are very old trucks, why should I take it? I've shortlisted it. I may have, because one of the problem which you are having is you have allowed 15 years trucks.
True, my lord. Because we have said that they are all eligible.
Because everybody has the same rate. And everybody having the same rate, now you are going on the basis of, you are taking them on the basis of the age of the truck. Making it
That is
one.
how
place.
this real number comes.
Now, can it be the idea in view of that interpretation so given by the coordinate
No,
bench?
that interpretation, my lord, if I may take your lordship to the interpretation given by this honorable court earlier, my lord. May I take your lordship to the judgment? Because, my lord, the honorable court went to the question of proportionality. But before that, if your lordship, my lord, kindly comes to page 70 of the earlier judgment, my lord.
Page
Page 70, yeah, my lord.
70, yes.
The judgment starts at.
Hmm.
Starts at page 63. May I draw your lordship attention to paragraph 16, my lord.
Hmm.
There is no dispute that the petitioner, may I read it, madam?
Hmm.
That the petitioner belongs to MSME general category for which 6 tank trucks were allotted. It is also not in dispute that the petitioner was placed as serial number 5 in the MSME general category. The allotments have been made by considering the number of vehicles offered by the tenderer vis-a-vis the number of vehicles owned by the tenderers. Respondent number 3 had offered 5 vehicles, all of them being owned. The respondent number 4 offered 5 vehicles, out of which 4 were owned and 1 was attached. As per paragraph 6(2) of the order of dated 23/3/2012 of the Ministry of Micro, Small and Medium Enterprises, Government of India, in case there is more than one such micro, small enterprise MSE, the supply shall be shared proportionately to the tender quantity. This is also indicated in clause 5B of the part 6 of the tender document relating to reservation, which says that in case of more than one such micro, small enterprise, supply shall be shared proportionately from the MSC party. So, my lord, on this foundation, my lord, the proportionality has been discussed. Now, if your lordship kindly goes to the, my lord, the notification of the Ministry of, my lord, MSME, the Development Commissioner, that is at page 57. The clause which has been discussed by this honorable court in the earlier judgment is price quota clause, my lord, it starts at page 57, relevant page 59.
Yes.
Clause 6.
This
Price
remains
quotation,
the same.
my lord.
This remains the same.
In fact, my lord,
This policy has not changed, I suppose.
this policy, my lord, we do not have any document to show that this has changed.
So this policy which was there of
That-
2012 remains, and it is the basis on which you have made.
Yes.
Now here you have tinkered it with something additional words.
Yes, yes, that's right. And that's why perhaps, my lord, because the earlier NIT I could not, my lord, obtain, in respect of which the, my lord, the earlier requisition was decided. That, my lord, the authorities could not find
With the
out.
objective of the
Clause 6, my lord, if your lordship kindly reads. Price quotation in tenders, I read it, my lord,
Huh?
clause 6, page 59.
Yes.
Price quotation in tenders. One, in tender participating micro and small enterprises quoting price within the band of L1 plus 15% shall also be allowed to supply a portion of requirement of bringing down their price to L1 price in a situation where L1 price is from someone other than a micro and small enterprise, and such micro and small enterprise shall be allowed to supply up to 20% of the total tendered value. Then clause 2 is important, subclause. In case of more than one such micro and small enterprise, such means L1 plus 15%. So, my lord, this perhaps, my lord, in the earlier judgment, this was taken to be, my lord, for, my lord, all the, my lord, tenders. That is how, my lord, the interpretation that has been given. in
But
the-
you have accepted it. State is.
No, that's why, my lord, I submitted your lordship may take a different view because, my lord, this.
It's very difficult to take a different view, no? Because state is concept. You have allowed all this while the challenge is not there. So therefore, why don't you think that the division bench should be in a better position?
That is, your lordship is right on that, but the question now is here, my lord, at this point of time, in the event your lordship, my lord, allows the reputation. For that, my lord, your lordship, perhaps, my lord, would like to know what have been doing with the trucks they have already offered.
Huh?
The trucks which were offered, and eventually, my lord, if it is distributed proportionally, it will go to them, it may go to them 1 or 2, whatever, my lord.
Okay, 2 trucks.
2 trucks, then would there be a position to, my lord, give those trucks because, my lord, the position has changed now. They may have given it to some other company. It may not be available. That is one aspect also, my lord, your lordship may like to know. Otherwise, my lord, the ISP is put into great difficulty. Now, if we have.
And
to, my
not
lord-
only that, the problem arises, did they challenge immediately?
No, my lord.
How
The
long?
challenge was not immediate. This writ petition was filed on 24/3/2023. And the allotment orders were issued. Once I get this, it was not challenged immediately and therefore there was no stay, my lord. 40 months.
When was the allotment order issued? Yes, Mr.
December
Tiwari.
2022.
Huh? December?
Challenge in December 2022.
Now, question is, if they are asking for proportionate, don't they have to also make those other persons also a party? How do I take care of that?
Because, my lord, yes, my lord, that is what I am.
They may
also, my
agree.
lord.
They may agree. Just for example, they may agree. But others,
Because, my lord, they do not keep their trucks idle. They try in different companies. And even if, my lord, we allot to them, my lord, they may not be in a position to, my lord, that fact, if you're is not before Roche, my lord, that will not.
because they are the question is, all others, he is number 15,
18.
18. Now being 18, he is way down the list. You have completed till number 5 or 6.
Right.
What happens to the next 11? Whether these 11 would be able to give it, then what happens?
Unless, my lord, those facts are before lordship, my lord, this will not be, my lord, substantial justice, my lord, even if your lordship, my lord, allow the petition.
Because the others have not come. Why don't you give them 2 trucks matter over? Don't disturb anybody.
My lord.
Others have not approached, challenged it.
That may be a solution, my lord, provided.
That
he
is
can-
the only
but,
solution.
My lord, provided, my lord, he can even undertaking that the moment we give it, he'll be able to, my lord, supply the.
That is another thing. They will give an undertaking that is, this court will take care of. This court can then pass an order without touching because the others have not approached. He has only approached and he has proportionately would have been allowed, would have got two. So, and he has only offered three, na?
We offered,
Three trucks.
no, 8 trucks. He offered 8.
Anyways, eight. He will be only two as per proportionately if we go. Then others having not approached, if this gives an undertaking, you give it to them, then would it violate the principle Article 14? Taking into those medical judgments. But there are also cases, many cases where the person agreed is not before the court, then he would have at best got only two.
What may happen, my lord, thereafter, my lord, I may take instruction from the RC whether they are agreeable to give, my lord, if they agree, my lord, this item will be over.
But you
then,
have
my
to
lord,
think
the
on the
moment,
Article 14 also.
Then, my lord, the moment, my lord, this is allowed and we give 2 trucks to him, my lord, the others will like an enforce this or may, my lord.
The others means they have not come. 2 years have gone by. These were given in 2022. Now, if I pass an order to the effect that others are not agreed, he is only agreed. He only would get only at best he could have got two if proportionately applied. Then in that regard, can this court mold the relief in that regard? Provided you give him two. Then the problem, because there is a problem which will assign, because DA has not made those people a party. And today, if I direct them to give proportionately, it will have a far-reaching consequences. They may not be able, and then how do you take care of running their day-to-day affairs?
On this, can I take instruction, my lord, one day time? If they're agreeable, perhaps, my lord, that may be a solution.
You know, this is the only, otherwise this court has a difficulty, means, yes, can be done, but why should this court necessarily? It is only making a judgment of coordinate based per inquiry is a very difficult thing. Though I have said it in that judgment, what you call that old pension, new pension, I have mentioned it, but it was very difficult to say. Although there is a judgment of 1975 Supreme Court wherein said Pradeep Kumar has spoken. That one single fact, this way or that way, would be a world of a difference. But that is there. But what the coordinate bench have stated is that on the basis of the policy. So you are therefore we are therefore, otherwise if I hold, otherwise that means you are not holding to that policy. That is another big problem, you see.
I understand.
The policy says that there has to be a proportionate thing. So, Mr. M.K. Chaudhary, the learned senior counsel appearing on behalf of the Indian Oil Corporation, submits that he would like to seek for some accommodation in order to bring on record, if possible, the earlier tender on the basis of which the judgment was passed by the coordinate bench. Judgment dated 4/12/2018 was passed in WPC number 1604/2018. Is this matter again on 29th of October? Ask your senior to be present on that. As it is a admitted case that you are not in possession,
Yes, we are not in possession. One middle building lordship.
now
is also-
your only issue is that order 39 rule 2A application is not being accepted.
Yes, lordship.
Nothing else.
And there was no other court lordship. My humble submission is this lordship is order dated passed by this honorable court 21st of May 24 is made absolute. Then this matter can be decided, will be decided in this room.
What order?
For police help, if at this order 21st of May 24,
Ah.
Police Commissioner and OC Basishto PS were directed to enforce the injunction order passed by the court.
What is the injunction order? Thereafter they stopped,
Thereafter they have.
but that is an ex parte injunction.
That is that. Yeah, next
Huh?
party injunction, yes, yes.
That's an ex parte injunction.
Yes, yes, Lord.
The respondent number 6 shall ensure that no further demolition of the building in the land so and so is being carried out.
If it is made absolute,
So there is no question of enforcing that award shall ensure that no further building is
Yes.
demolished. Now, list this matter again on 1st of October 2024, on which day the Register Vigilance shall obtain and on which date the Register Vigilance of this court is directed to obtain a report from the District Judge, Kamrup Metro, as to whether the court of the Civil Judge number 1,
senior division.
senior
Now it has
division
been
number,
transferred.
huh?
Transferred to, now the suit has been transferred
2,
to civil judge number 2.
then why you are not filing there? What is that? That is the basis why you have approached this court. Why you are not making that submission?
filed lordship
You
on this
came up
because
only
lordship,
on the basis
most
that
powerful minister is behind the scene.
we have
lordship.
not made the powerful minister a party.
We cannot,
No, you cannot, then don't come up. You can't make that
If
such statement.
otherwise they will again start demolition.
Then go there. It is already there. Then what remains here? Now, heard Mr. S.P. Roy, the learned counsel appearing on behalf of the petitioner. So Mr. N. Goswami appears on behalf of the state respondents, and Mr. So and so appears on behalf of the respondent number 8. Pusta. It has been submitted by Mr. S.P. Roy that the filing of the instant petition was necessitated on account of the non-compliance to the order of injunction dated
27.
27 to 2024, passed in Mizze case number 175/2024 in title suit number 95/2024 by the court of the civil judge, senior division.
BJ case number, lordship,
I've
170.
given Mizze case. No, civil judge, senior division number 1, Kamrup Metro at Guwahati. He submitted that that in view of the non-compliance, when the petitioners went to file an application under Order 39 Rule 2A of the Code of Civil Procedure 1908, the trial court refused to accept the application. And it is under such circumstances, the petitioner had no other alternative for which the petitioner had approached this court by filing the instant writ petition. The learned counsel appearing on behalf of the petitioners further submitted that in the meantime, the court of the district, the learned district judge, Kamrup Metro at Guwahati, have already transferred the title suit number 95/2024 to to the court of the civil judge,
Senior division.
senior division number 2, Kamrup Metro at Guwahati. And as such, he would be in a position to file the application under Order 39, Rule 2A of the Code. The learned counsel for the petitioner further submitted that till the existence of the order dated 27/2/2024, passed in Mizze case number 175/2024, the interim order passed in the instant proceedings shall be permitted to be continued. And he further submitted that these be continued. Otherwise, there is a likelihood that with the disposal of the instant writ petition, the respondent authorities may again resort to all illegalities, thereby violating the order dated 27/2/2024. So, taking into account that the matter, the reason for which the petitioner herein had approached this court is on the ground that the petitioner had no other avenues available in view of the title suit number 95/2024 being recused by the court of the civil judge number 1 Kamrup, senior division number 1 Kamrup Metro at Guwahati. And now the matter having being already transferred to the court of the civil judge senior division number 2 Kamrup Metro at Guwahati, the petitioner herein would be at liberty to file the application under Order 39 Rule 2A of the code, alleging if there is any violation to the order dated 27/2/2024, passed in Mizze case number 175/2024. And as such, this court is of the opinion that keeping the instant writ petition pending before this court would serve no meaningful purpose. First, this court, however, directs that as the respondents in the police administration are this court, however, finds it pertinent to observe that the orders passed by the interim order passed
On 21st/5/20.
on 21/5/2024 shall continue till the disposal of Miss case number till further orders are passed in Miss case number 175 so and so by the court of the civil judge number 2.
So 48 to 53.
I have prepared stress matter item wise, will be continued. Before in the, as per 17, now the serial numbers are changed. So this one I.
Why did you call a summary of so-called notice dated is barred by limitation In as much as the period.
Well, that point will go now.
No, that point not necessary. In the present, no opportunity of hearing provided before passing the impugn order as mandated under 74. You asked for hearing.
My lord, in this matter, I asked.
But in all these cases, only summary of so cause no.
Only all cases.
That is what they say, my lord. My inspection says that, my lord, there's a attachment along with that, my lord, DRC number 1. That is the solution. Because everything has been elaborated, that is what they say.
My lord, in the.
Where is the attachment?
My lord, yes, Lordship may kindly see one case, my lord.
In one case, item number 49, they filed affidavit.
Where is it? Let us see that.
Item number 49.
No, the first item.
First time, no affidavit.
So,
Item number?
Item 49, Lordship may see, we have already clarified that, sir, 49.
Nine.
WBC 3919.
This Aurora Fine Arts.
Yes.
Aurora.
What do you say?
Affidavit filed on 28/8/2024.
No, this is annexure 2. Are you saying this? This is the attachment.
Yes, that's according to them, my lord, that is.
No, that can't be so.
Understand. Going by the, my lord, act, my lord, yes, very clear.
As per the rules, it cannot be so.
142 is very clear. Otherwise,
Oh.
my lord, going by 73, at least we can infer that this may be a so cause. But 142 has made clear. my lord. After so cause notice, my lord, additionally, the summary will have to be there. along with
And
the-
this is the thing which you are to carry out. Where is that?
Sir, my lord. Same question came up before division bench of Jharkhand High Court.
Huh?
Jharkhand High Court held, my lord, summary of so cause notice is not so cause notice.
Yeah, I'm
As per
holding-
section.
Let me also hold it.
Para 7.
Very neat, Jharkhand High Court. Yes. Finally, see, notice under section so and so, the proper officer shall serve along with the notice under so and so or so and so a summary thereof electronically informed DRC 1. Number B, statement under subsection 3 or subsection 3 of so and so a summary thereof electronically in so and so specifying the details of amount payable. Then 1A, the proper officer before service of notice chargeable under tax so and so, under so and so, as the case may be, communicate the details of tax interest as ascertained by the officer in part A. So this is in terms of 142 1A.
One
this-
A, my lord, is given prior to, my lord, the so cause notice,
Huh.
giving an opportunity to make the payment. Then, my lord.
You
can pay-
give this.
No,
And
not
thereafter,
1A, my lord.
huh?
DRC 1. Lordship will see the repetition.
DRC 1A.
Only one.
142.
DRC 1.
Page,
DRC 1 is the summary.
page.
DRC 1 is the summary, there is no quarrel. But this is prior to this. Annexure 2 is prior to DRC 1, isn't it?
No, it is. my lord,
Before,
that-
yes, kindly see.
Well-
1A says the proper officer before service of notice to the person chargeable with tax under so and so under 73(1) or subsection 1, as the case may be, communicate the details of any tax penalty as ascertained by the officer in part A of form GS
Lord.
DRC 1. This seems to be the so, annexure 2.
My section says, my lord, as already clarified by so and so, the proper officer issued DRC 1, which was summary of the so cause notice. The attachment in DRC 1, which is the so cause notice, and in the said notice, details of under declared tax amount is given along with reasons thereof in order to give the petitioner an opportunity to clarify his case of under declared tax amount. Apart from that, no other so cause notice. That is the.
No, what is this annexure 2? Annexure 2 is in terms with 1A.
Annexure 2 of the writ petition is the attachment in annexure D1 or DRC 1, which is the so cause notice. That is what they might have repeatedly the affidavit of the day.
Yeah,
Details of
annexure
other-
2 cannot be the so cause notice.
Cannot be otherwise.
Annexure 2 seems to be in consonance with 1A. Kindly
One.
see.
DRC 1. But my lord, what DRC 1?
Kindly see number 2,
No, I understand.
142(2), where before the service of notice or statement, the person chargeable with tax makes the payment in interest so and so. interest on so and so, and where any person makes payment of so and so, whether on his own ascertainment or communicated by under 1A, he shall inform the proper officer. So this 1A is to have been given, should have been earlier.
Yes.
Or you may have given, it's a different thing, but this can also be construed to be 1A also.
Lordship may kindly see page 450 of this ballot. 450. The format of DRC 1A has been given. We'll see when we can compare
450.
whether it's same or not. 450. Yes,
450?
451. 450, yes, 450. DRC 1A.
451A, yes. Case pending reference, please refer to so and so. You are hereby advised to pay the amount of tax as ascertained above along with the amount of payment so there. You are failing which show cause notice will be issued. So this is the step. This is certain. So this is
Not
not
the-
even 1A.
Not even
Now,
one.
what is this document? Attachment to the determination of tax.
Sir, it is as per 142, I suppose. 142(1) says the proper officer shall serve along with the notice issued under section so and so. A summary thereof electronically in form GST DRC 1. The statement under subsection 3 of section 73 or section 73 of section 74. A summary thereof electronically in form so and so specifying therein the details of the amount paid. So this attachment part may not there even in 73 of the act as well as well in 142 of the bill. That's why they are referring it to be a scope of notice because everything, every detail has been given here.
It was given, my lord, along with summary of SOCO's notice. Date is same, your lordship. Annexure
Ah.
2 and annexure 1, date is same.
Now, date is same. So this is the attachment.
Fine.
But this is not the show cause.
This is not. So 1 and 2, my lord, ingredient of proposed notice is also not there. They are
Huh?
not, they are not asking me to give explanation. Is the,
And where is the reply? No reply.
no reply. In this matter, no reply, my lord. In fact, section 73(1), if your lordship sees, my lord.
In fact, this is, they have missed out the writing of one letter. One line. In fact, this is a show cause notice.
There was one line to show cause within a time.
Ah,
Only one line.
only one line. In fact, what they did, they saying this.
They are filling up this kind of chart and all. But the rest
Everything,
are already
in fact,
informed.
they excess utilization and GST are excess Seaman. But you see, briefcase excess ITC utilized under GSTR 3B. GSTR 3B.
Check it out, right?
73. Statement under subsection 3 or subsection of section A, summary thereof electronically in DRC2 specifying therein the details of payment, where a person referred to under Emmanuel had made personally, where a person chargeable with the tax of so and so or Emmanuel within 30 days of the notice under ER or when days to Iman, within 7 days of the notice issued under Iman, but before the issuance of the order under subsection 3, he shall intimate the proper officer such payment insurance or the representation under insurance referred to in subsection 9 of Iman or so and so. In notification under so and so, the summary will be regards to 1. It's been clear. Summary of the order under 52, 62, 63. And in the other cases,
Same thing.
you submitted reply no.
In my lord, item number 48 and 50, I have filed replied and I sought for personal hearing your lordship. That was not given by them. And, in the item number 49 and my lord, 48 and 50, I have given my lord, I sought for my lord personal hearing, that was not given. 49, my lord, I have not asked for, I have received so-called notice and my lord order under section 73. 50, I have replied, my lord. 50, 52, my lord, I have not given any reply, my lord. 53, my lord, same your lordship, reply has not been. 6 decisions, my lord, I have raised, my lord.
Number 51, I have received only somebody else. I have not replied in order.
Which High Court said there has to be an independent notice?
My lord, Jharkhand High Court, your lordship.
Huh?
Compilation I have given your lordship.
Where
Parasite
compilation?
compilation of judgment, my lord. Yesterday, on the last of the.
Yesterday. And
Then
somebody was
I'll-
asking for these documents that file, who was
In
asking?
file, my lord, I think that judgment is there. Or your lordship, I will. file.
Madam, you gave me this, didn't you?
Series, this was for the series.
Yes, you gave this. Who was asking for this document? Somebody was asking this.
Jharkhand का नाम है।
Anyway, where is that?
My lord, I am handing over my copy. I have.
And madam, what is your case?
So somebody of suppose notice was given, no suppose notice was given to me. Just to pay somebody of suppose notice and finally the order.
You're referring to which judgment? The no notice was contemplated on the language.
My lord, Jharkhand, your lordship may kindly see. Para 17 NKS Service Private Limited. NK Services Private Second Judgment, my lord. State of Jharkhand, my lord.
Jharkhand.
My lord, NKS Services Private Limited versus State of Jharkhand. Second judgment.
This
First
is
is my lord,
Nikas service.
and the sir.
Yes, what is this?
Para 17, my lord.
70?
17, your lord. In fact, this is my copy, it is marked, I think. Next is my lord, Mahindra and Mahindra. It is in respect of 74.5, para 11 and 18, your lord.
This is for hearing.
Hearing, my lord, 74, 75, 75. Silver O. It is in respect of, my lord, violation of rule 26(3). It says, my lord, unsigned document and which loses its efficacy, unsigned so-called notice or
And
order.
what is this? The other one?
Other one is, was, my lord, 456, it is in respect of signature, my lord. If it is not electronically signed, digitally signed or signature, then that document loses its efficacy. And LC infra.
Where?
Para, my lord, first your lordship may kindly.
Which one?
Silver O. After Mahindra and Mahindra,
Huh?
Telangana High Court.
Telangana.
Telangana.
Name?
Name is Silver. That printed version, it is not reported, man. Was taken.
Mahindra. Then
Para 9, AV Bhanoji Rao. Para 4, 6 and 7. In note, short note, my lord, I have written paragraph.
what is the name?
First is Silver. It is printed version, that online copy is there.
Silver Oak.
Yes, para 9 year also. Is delivered by Telangana High Court. Next is, my lord, AP Bhanu.
Wait.
My lord.
So this is on 26(3).
3. So order.
In all these cases, no, nothing is
No,
mentioned.
no, my lord. Only name is there, no signature, no digital. That
Yes,
means-
Mr. Gogoi, what do you say?
And according to them, my lord, there is a dongle for each officer. Moment they, my lord, use the dongle and enter into the portal, and if they issue a particular, say, summary or an order, their name appears, my lord. According to them, that is the electronic signature. That's what they explained to me.
You have seen many other cases where it is e-sign.
Like a seal, my lord. I've seen that.
We also have the dongle. I have not used it. It's a different thing.
Got it.
We are also given a dongle for a digital signature. The dongle, the moment we put it, will come up date, time, everything. As you see in many orders of the year. Na?
In fact, in the contractors also, they are required to have that.
So everything will become, not by which the name and designation. I think there is a sign, the moment you sign it, you cannot alter it, the time. Exactly the time comes in. Because this is to be given as per the Information Technology Act. No?
Yes.
Kindly see 26.
That law civil fine, well, here's, rule,
26 2.
yes, 26.
So why I'm doing it, as I am doing it for, I'm already setting it aside. I think why not make that thing
Make some
also
of them
clear?
that one.
Huh?
Which are, my lord, that
Yes,
is
because otherwise this will again be another issue.
another job.
This has to be digitally, all notices, certificates, so and so, and offer the year to be issued or through notices, so and so, through digital certificate or through e-signature as specified under information. Digital signature certificate is specified under the provisions of Information Technology Act. Digital signature. Because tomorrow again, there will be a big issue tomorrow. Electronic signature, digital signature certificate means digital yeah, under subsection 35. 35. Any person making any application in the certifying authority for the issue of electronic signature in such form as may be prescribed by the central government. Every such application provide every application shall be accompanied by certificate and receipt of the application What is the content of a digital signature? Someone digital signature shall extend the RIA while complying with the digital shall be issued only after a digital signature application is so the application, the digital shall be generated by the certified.
Rule B4
Hmm?
of the Information Technology Certifying Authorities Rules 2000.
Huh?
Rule 3 and 4.
Certifying authority rules. Yes, that is what.
2000. 3 says, my lord, manner in which information be authenticated by means of digital signature.
3.
4, yes. Rule 4 says creation of digital signature. So 4 will be, my lord,
Sign an electronic record or other item of info, the signer shall first apply to the hash function in the signature software. The hash function shall compute a hash result of standard length, which is unique for the purpose to the Iman and the signer's software, transforming the hash result here using the signer's private key. The signing resulting signature shall be unique to both electronic records and private key used in it. The digital signature and Iman attached to the image shall be stored or transferred. Public. What is contained in the digital signature that is important? No? Issued with a designated expert. the digital signature certificate. The generation of BR on inspection. His name will not appear. In your case also, no signature.
Not even digital sign.
May have a larger ramification. Can I at least pay for 1 day's time, madam? Let me have,
Yes,
because madam, this digital signature will be another issue now. Not only related to, madam, limited to this particular batch of cases, but there may be other, madam, orders where, madam, though, say 73(1) has been issued, but not, madam, digitally signed. In that case, again, there will be, madam, further issue. And let me have the information, will give a larger ramification.
But you have raised the issue.
No, no, yeah, I understand, madam. At least, whether, madam, if at all it has not been used, then, madam, we will be victim. If
We'll take
there,
it up
madam,
again. We'll again take it up next Tuesday.
at sometime, madam,
Monday or Wednesday, man. Not on Tuesday.
Thursday.
Thursday.
Next Thursday, we'll take it up. You just find out.
yes, yes. In fact, required, I
What-
may
you
ask
see,
some officer to be there, madam. These are very
You have
technical
any
things.
document of the government, you appear for the health department, na?
Madam,
They sign. You have any document of any signature?
their instructions, yes, madam. Only,
Eh,
madam, their
eh,
names are
eh,
reflected.
No, no, there's a time, everything is reflected. Can you see? Any document digitally signed?
From the secretariat, madam, all, madam, instructions come under digital.
So that is any document you have?
My lord, you're looking at seat, digital signature.
Yes. Yes, signature not verified, digitally signed by DS goods and service tax, so and so date, time. Because you can't alter later on.
Yes, that's why, madam, there's some authenticity will have to be there.
Yes, so this is how the signature not verified. This is not signature verified, but in the government, they think the signature verification.
But date used to come. Date,
Yeah,
time.
date,
everything
time.
come. Yes, time also come.
Because once it is digitally signed, you
That's-
cannot alter it.
Madam,
But in these documents, it is
But-
not. Maybe you may take an instruction to the effect.
lordship, can I?
Yes, yes. You may take an instruction to the effect that if it is in the portal,
Madam,
what does it say? In the portal,
there, time, date, everything is there. So,
yes, that is signed by so and so, date so and so. So the name has to come. Who has signed? Here the name has come.
date, time and all.
Then date and time has not come. But let us see one thing in the rules, the form. In the form, what is the signature is required? I mean, how do you put the signature there?
Kindly have a look at the index, my lord, index part of this, my lord, direct. Lordship will find the relevant part, my lord, Roman 17.
Index,
My lord, yes, index part, Roman 18 page. At the very first one, Roman 18.
yes.
My lord, lordship will see, my lord, in the middle, GST, DRC 1. There is no format for, my lord, proposed. It starts, my lord, DRC 1, summary of so-called purpose.
Where?
In the middle, my lord, page, my lord, 449.
18.
18
18,
page 449. Also, you will see the page part, my lord, in the right side. Page
449,
449. DRC 01, summary of so-called knowledge. DRC 01A, intimation of tax ascertained as being payable under section 73(5), 74(5).
No, I'm not saying this. I'm not saying about DRC one. Because you gave this DRC one. There whether signature I'm
So
saying.
why I'm saying is, my lord, also will see whether DRC six is, there is a format for apply to the Sokos notice. But not a single my lord format, my lord, indicating my lord, this will be the Sokos notice. In the GST my lord. main-
No, there is no given.
Yes.
So the, because that will verify. In fact, what you did in Annexure 2 was a show cause. You gave everything.
In fact,
You
my
should
lord,
have
this is
asked them only within that letter, because that was your attachment.
In fact,
In fact, that is okay, but only problem is that it should be
Page 29, my lord.
page 449, if you see signature, here signature is given. Now DRC one signature you have to put, how do you put this signature? This has to be put electronically. Page 450. Page 450.
yes, my lord, proper officer, signature, designation. Upload the text.
No, you are seeing 450A. 450.
Yes. my
This
lord,
is
the
DRC one,
one,
signature.
Yes, signature, name, designation, jurisdiction, address.
Place of supply so and so. Now here therefore, this signature has to be digitally signed. So therefore, are these signatures digitally signed?
Therefore, if they are of the impression that, my lord, this is the.
And interestingly, 1A, kindly see, page 450. It says that you are hereby asked to pay, you are hereby, now kindly see. You are hereby advised to pay the amount of tax as a certain about so and so penalty, failing which so cause notice will be issued under 74(1) or it may be 73(1). In case you wish to file any submission so and so, you can furnish in here. Now here you see upload attachment.
Yes. In fact, my lord, in my lord, the summary also, my lord, they have referred to as Sokos notice. In fact, my lord, there is a number also, reference number.
The
But
PDF is there, but the PDF is this.
yes, but that, why no, it has not been enclosed or not there? Because the serial number is different. Also, you'll see that part.
Which one?
Well, the, in the summary of Sokos notice,
Which matter you are referring to?
my lord, WPC 3910, where my lord, we have filed one affidavit.
3910, yes. You see Aurora Fine Arts PDF, SCN. This is the show cause notice.
It says, my lord, after, my lord, this, my lord, tax period, July so and so, Act NA, section, subsection under which Sokos notice is being issued 73, brief so and so. Then lordship will find Sokos notice attest. Then, my lord, in the
bottom left name has been given designation, but no signature or date.
This should have been your, they have mixed up with 1A.
my lord, appears to.
This should have been given prior to that, before 73(1). But what they did, they issued this as a show cause,
Yes, sir.
page 30.
My lord, lordship will see page 38 for a moment.
38.
Yes, after the addressee,
Ah.
name of the addressee, my lord, lordship will see Sokos notice statement reference number so and so 465, last three numbers. So some reference has been given. And this number, they refer to, my lord, DRC one. So according to them, my lord, whatever is there in DRC one, they will give that impression that that is the Sokos notice.
Now this seems to be the order, Annex of 5.
Fact, my lord, in one, my lord, that Jharkhand, my lord, case, which has been relied upon in another case, there also, when it has been stated that GST, DRC one has been issued, but even in that particular notice also, the date, my lord, of reply, say within 2 weeks, that has not been mentioned. Had it been mentioned, my lord, it could have been taken as a service. That is the observation made in my lord Jharkhand. The one, my lord, that my learned friend is relying upon, it has been relied upon this Jharkhand, it is subsequent to that. Jharkhand. Have the date and time, as Lordship has stated, one line that by so and so you reply, why you should not be penalized or anything. That perhaps it.
I've already heard the matter. I can make it CAV. You just give me that information.
Keep it part heard, my lord.
Again, you see the time, it's not that, you see, okay, 26, do you see?
Only on that point, my lord, on 73 one, my lord, I have in fact, my lord, talked with them also, they could not, my lord, give me a satisfactory reply to me. also.
In fact, on, my lord, on 16/8, you also directed them to obtain instruction.
No,
as
that I have
per
written
No,
instruction,
it's okay.
we have filed a affidavit also.
It's okay, for that it's okay. Not on those. Oh, yeah, these papers I've got it. I'll take your OC. Keep this, you have underlined there.
And in my note, short note, my lord, I have given paragraph number.
This one? Because that's for creative pilot. Okay, matters having been heard at length, the matters be again listed on 26/9/2024 at the top of the list, taking into account on which day Mr. B. Ugoy, the Learned Counsel for the Finance and Taxation Department of the Government of Assam, shall apprise this court as to whether the show cause notice which have been issued to the summary of the show cause notice so issued to the petitioner contains the digital signature in accordance with the Information and Technology Act 2000.
Deeply.
একটু ঘুরাই দিন, একটু আসো। Here.
They filed that affidavit. You have already received lordship.
This is that matter, no?
Yes, lordship, ex gratia compensation on account of the death of our husband.
Oh, mister, you have not understood my point. This FIR, when was the person killed? On 25/11,
24/12,
24/12.
2009. Lordship.
How did you say that he was an NDFB militant? Was there any records anywhere earlier found? Is it after killing you come to an opinion that he's an NDFB militant? That was my specific question. You are not answering to that. All your FIRs, everything are subsequently. It's very easy. Anybody can come up with their, look here, after killing, you can put a pistol in his bag and do everything. It's not the question. You say you are denying the petitioner the claim on the basis that he is an NDFB militant. If that be so, there has to be some materials. There can't be a material which has come into a region after killing him. That is the only issue I've been raising, and this is the matter is going on from 2016. You want to have a decade-long anniversary of this? Then
I have produced the documents, then Lordship directed me to put everything on affidavit. Lordship.
understood, but the question therefore I have raised it many, many times is this. Whether you had any other document. He is otherwise entitled to this 3 lakhs, no, madam?
Yes, Lordship.
Entitled to this 3 lakhs. Give him the 3 lakhs, but you have no. If it was the other case, I would have asked them to make the good amount payment. Minimum to 15 lakhs is done. But she's only asking for 3 lakhs where you are not paying. This is to you, because of the army authorities, he was killed. Isn't it? The crossfire between NDFB and yeah. He was killed. Unless you show me any document to that effect that
Army
yes.
authority is not a party. Army authority is not a party.
But it was a joint operation, Lordship.
Army or not is not a question. You have a particular circular. You make payment on the basis of anybody killed during this borough era. Government servant you don't do, but others you give. Why not the petitioner be given? You say that he is an NDFB. But where is the document to show that he is an MBAB? You have not been able to show anything. Then there has to be something. After killing, do you know that he's an NDFB? It's very easy to say. You can make anybody an NDFB after killing.
Take it up on Monday.
Monday, there are already 54 matters. We'll have it after vacation.
That may be
Mm.
fixed, Lordship.
List this matter again on 23rd of October, 24th of October 2024. On which date the Learned State Government Council, this court have perused the affidavit filed by the respondent number 5. From the documents which have been placed on record, it is seen that it is only this court have perused the affidavit filed by the respondent number 5 on 17/9/2024. Pursuant to the order passed by this court on 29/8/2024. From the documents which have been enclosed, it is seen that all these documents were pursuant to after have come into existence after the incident which led to the death of the son or brother, husband
male
of the
son.
petitioner. This court had made specific query as to whether there was any records available with the police authorities or any other authorities to show that the husband of the petitioner was an NDFB militant. List this matter again on 24th of October 2024, on which date an attempt shall be made to dispose of the matter.
Then 7 are both together, Lordship. These are relating to Lordship cancellation of GST registration. Lordship, this is the stand taken by the respondent in their affidavit that once a registration is cancelled, it is not liable to be revoked.
Huh?
Lordship, this is the stand taken by them.
I've
Once a
seen an affidavit is fine.
Lordship, they have filed an affidavit. Lordship, I am just placing one, Lordship,
Though his resignation was cancelled on Iman, he continued to do without taking recourse to revive the registration. Yes, then
Lordship, the affidavit, in the affidavit, they are saying they are asking me to take a new registration. Lordship, I am in this.
what is this?
Lordship, Finance Act, Lordship, I will place only one
Why should I
provision.
look into this? Because you have already made an argument that this act does not hold the field today. It has not been notified. Why
But
should I
Lordship,
look into it?
only in respect of 16.6 which has been given, only because of they have said that in the affidavit that it cannot be revoked. It is specifically laid down.
No, but that provision has not been brought.
It has not been brought, but Lordship, they have,
No, madam, you can't play hot and cold. Don't come up with all these things.
But-
Didn't you submit yesterday that this act has not come? Didn't it, Mr. Khan? Huh? You can't come up with this. If it was before some other judge, he could have, but not before me. The fact that when the registrations are cancelled, and the registrations are being cancelled on the ground that you don't file your returns within 6 months.
Lordship, this is what has been laid down newly, that if you, if the court revokes the registration, if we file the registration, if we file all the returns within a period of 1 month, I'll be able to get all my ITC, all the ITC, because Lordship, when my registration is cancelled, I have got two losses which have occurred to me. The purchases which I have made, I don't get the ITC for that. The ITC is gone because my when the registration will be revoked, Lordship, I will not get the ITC. The ITC, there is a time limit. They give me only 1 year to take the ITC. If I file my returns beyond that, I will not get the ITC. Second loss, Lordship, what I have is that if I issue an invoice to the Lordship, my dealers, to whom I have Lordship sold the goods, Lordship, they will not make the payment until and unless I have a valid registration. The reason why is that, Lordship, they will not get the ITC because my registration, and if my registration gets cancelled, they will be liable to pay not even only the amount of the money, but also interest and penalty, as had happened in last date, Lordship. Yesterday the case was there, Rashidul, in which Lordship has demanded back because the dealers had, the registration was cancelled. So I was Lordship penalized by levying penalty, interest and everything. So I am Lordship doubly jeopardized.
You are
Then
not doubly, because of you, other people are suffering.
Other will also suffer, I will also suffer, Lordship. But
We allow it subject to cost of the 10% of the ITC.
Lordship, we will pay all the taxes. Immediately, Lordship, I will
No,
pay all the
10%
taxes.
of whatever benefits you are going to get. Any benefit, 10 or 15% as cost to be deposited in the legal services. This is a better source. And another 5% to the welfare of the GST welfare. No, something has to be done because
That
this,
is-
first and foremost, you have the mandate of earlier, it's okay. We are in 2017, you may not know. And that is why the government gave you a lot of exemptions to the effect. But as of now, you should have been. Why you are not filing your return 6 months and then you approach this court after so many years?
Lordship, there are various reasons because of which,
So
Lordship,
there
we are
cannot
not
be any
unable
reasons.
to.
Then stop your business. Why you going doing? You are carrying on your business out there but not getting yourself registered. What has happened during this period? You have stopped your business.
Lordship, I am not able to raise any invoices, and what has happened is that,
So
Lordship,
you are carrying on illegal business.
no, Lordship,
Yeah.
I will,
There
I will
must
be
be
able-
something.
Lordship,
There are many judgments. I think Jharkhand and many other courts have passed nothing doing. If you have not done it,
Lordship,
cancel, you go for fresh registration.
Lordship, there are many judgments which are in favor of the petitioner, and they have revoked the registration. Even in, Lordship, the coordinate benches of this court have also,
Show me that.
Lordship.
Let me refer this matter to
They
the
have
division
penalized me.
bench.
They have
Let this
penalized.
matter be referred to the division bench.
Lordship, they have penalized.
I
me.
am not doing it anything.
Lordship, the
Let
petitioner
this
not.
matter be referred to a larger bench. You see after that disposal,
Lordship, the
let the chief first fix the bench. Then that division bench will take up the matter.
Lordship, Lordship, the courts have penalized me by asking me to make all the tax, interest, penalty, everything. And then
And
ready to
also,
do
I am
that.
allowing only subject to 10% of whatever tax, interest and penalty is deposited as cost. That is only. In addition to that, because this is the only way. I'm not allowing, then in this court, I'm not buying. You see, what are the cases? I have, because all these orders which have been passed, I have not followed any of these orders.
Yes, your lordship.
All the orders which I have passed is only, I'm remanding the matter to that effect where so-called notice or notice or reply has not been given.
Lordship, in all these orders, the Honorable Court has given liberty to approach the authority. And for consideration upon compliance of the rules and section 29 and rule 22, as regards updation of the default returns and payment of tax, interest and penalty. Lordship. That's the only observation made by this court, and it has been remanded back for consideration by the department. Lordship. In the case of Sanjay Nath, Lordship may come to operative para 6, 8 and 7. 6, 8 and 9, Lordship.
Who is the concerned authority?
Lordship will the assessing authority in item number 6, it is
No, as per the GST, who is the concerned authority?
will be the Assistant Commissioner of State.
An appeal lies somewhere, na?
Lordship.
An appeal lies.
Appeal lies to the appellate authority. In
Then
my
why-
case, item number 6, that was rejected, Lordship.
Huh?
That was rejected.
Then you want this court to remand you back to that court, that authority who initially rejected. His appeal order has been dismissed by the appellate authority. That order has been against that you are coming before this court. I should remand it back to that court, that authority.
Not to the
who-
appellate authority, Lordship.
Huh?
Not to the appellate authority, Lordship. To the assessing officer, Lordship. That will the Assistant Commissioner of State Taxes, who has rejected my registration, Lordship. Cancel my registration.
But if this court is going to allow this type of thing, then what is the end? You would never file.
Lordship for
You never file. Okay, let us come. We won't file now. Let me keep the money for the time being in my pocket. This interest which I have accrued, I'll pay it to one lawyer. He will file an application in the High Court and get an order of restoring. Easy.
Lordship, but that's not the stand of the respondent, Lordship.
Forget about them. It is my stand. I'm therefore asking you, why should this court exercise judicial review? What is wrong with their order? Accept mercy. Accept mercy, what is wrong with them? They have acted in accordance with law.
they have acted in accordance with law, Lordship, so far that's concerned. For obvious, for reasons, Lordship, sometimes the dealer is not in a position to comply to the time limit. For that, this is a hard step which has been taken. And if your Lordship come to the annexure 2 of serial number 6, Lordship, they have issued me the so-called notice on 6/11, which is uploaded on the portal. I am not supposed to check every day up the portal that if any notices come, I continue my business.
You should be more careful when you are not paid for 6 months.
I have not paid for 6 months. It is not there. It is only 1 month. My return was delayed. Immediately they filed, they gave the so-called notice, and within 10 days they have cancelled it.
Your was only 1 month.
Only 1 month, Lordship.
Let us see your case.
Item number 6, Lordship.
Item number?
6.
Name of the party?
Motley Bhuiyan, WPC
Matlab
2244.
Yes, let us see your show post.
Page 19, Lordship, Annexure 2.
Any taxpayer other than the composition has not filed returns for continuous period of 6 months.
Months. They have stated 6 months, not specific which 6 months. In fact, I have filed till October, November was not filed. And they have issued, in fact, on
No, here it
6/11
is
only.
said for continuous period of 6 months.
Lordship, that's a standard thing they are writing. They have not specified anything.
Okay, then what is your reply?
Then immediately that they have given me time, no specific time limit given there. Then the Lordship come to answer 3 on 18th, they cancel it. Order of cancellation. And if your Lordship may read, order for cancellation of registration. This is reference to your reply dated 17/11 in response to notice to so-called dated 6/11/2019. I have not filed any reply. Whereas no reply to notice so-called has been submitted. The effective date of cancellation of registration is 18/11/2019. So totally vague approach. No time limit provided for giving so-called, no time limit.
No, it is given, you are hereby directed to furnish reply within 7 days. Why I have not looked into? From the date of service of this notice.
Lordship.
Then, why didn't you submit?
That's what I'm saying, na? Because it was not personally served upon me. It was not, it was just simply uploaded on the portal.
Why,
I'm not supposed.
is it not required? Is it required to be only given
Yes,
to you
that-
personally?
Unless the notice comes to the notice of the person concerned, how can it be?
No,
taken
this
as-
will be all posted in it is given in
In the
the
portal,
form
right.
GST REG 17.
Yes,
This is
that's the
given
form
under
that-
what rule? It will be given
Rule
in this,
21.
it will be given in the portal.
Portal.
Then? What is wrong?
There is no wrong to that effect, Lordship. I'm saying that as a dealer, as a businessman, I'm not supposed to check portal every day for any notice.
When
or
you don't
something.
pay for 6 months, very well.
It was not 6 months. Let them say that I have not filed my return for 6 months. It was only for 1 month. Subsequently, I filed it for 1 month. That's November. Subsequent to that, because it was cancelled, I cannot file the subsequent returns.
Then you appeal.
I appealed it.
What happened?
Appeal said that because time but it was rejected.
No, one thing, the moment a so-called notice is issued,
Lordship.
is your AI not suspended? Your registration is suspended automatically. That is the norm.
But it was not, as per this election 2, it's not done.
That's
It's
the
not
requirement of suspension. During the pendency of the proceeding relating to cancellation, your registration may be suspended for which period and in such manner as may be prescribed. In your case, it was not.
Not done.
Then,
Then comes annexure 3, they have cancelled, where they
So
have
in
referred
your
to a
case-
so-called reply.
in
I
your
have-
case, is it your case that you did not submit for 6 months? I mean, it is not the case that you have not submitted for 6. There was no default for 6 months?
Only for 1 month. Only for 1 month.
What do they say out here?
They have not said anything in the affidavit, Lordship. They have simply stated that during
They say at page 44, the petitioner did not furnish returns due to the taxes of the state for more than 6 months. Hence, proposed notice was issued. They are saying they didn't say. And you waited for 5 years. Why did you wait for 5 years?
Lordship. Because I was not aware of the cancellation of my registration, we have stated in paragraph, Lordship.
Now, if there is a cancellation of the registration, it doesn't means nobody knows. Nothing happens.
My business was not running, Lordship, that time. My business was not running. I was not raising any invoice, nothing. And if I would have raised, then I've come to know that it has been cancelled because my all the statutory forms which have been can be generated will have been stopped. But since I was not running any business, I was not aware of that. Ultimately, I came aware of in February 2021.
Then also 3 years.
Yes.
How do you take care of that?
Lordship, I have stated in paragraph 7, Lordship.
So how do you take care of these 3 years? You are carrying on the business.
I was not carrying the business. That's my
3 years.
statement.
These 3 years also.
Lordship, during entire till 2023, I am not carrying any business. Till now, I'm not carrying business because I cannot do any business.
Then why you are not going for a fresh registration?
Because my past
Past is long past.
that still
Long
survives, my
past.
claim survives, Lordship.
5 years. 5
Claim
years
of
then
19
past.
1920, assessment year 1920, my claim survives, Lordship.
So, don't have a case. Why you have approached this?
Until November, I have already paid the taxes. Whatever business was done till the month of November 2019, I have already paid the taxes and filed the returns.
Where is your filing of your returns? Let's see.
Lordship page annexure 4 is the return for the month of November. Subsequent to that, I am unable to file because of the cancellation of registration.
So
And
you are
page
unable
26
to
onwards is
file
the
on the
challan.
cancellation of the registration. You filed this when? When did you file this? On 24/3/2021.
24/3/21, Lordship.
Then
10/26 onwards is the tax paid challans, Lordship.
they say that you are carrying on business.
How can I carry on Lordship business? I cannot take into.
That is the one which we are doing. That is the illegality you are committing. That you are carrying on the business without the GST registration.
I have specifically given a reply, Lordship. I am not carrying on business till during that period.
Where is your reply? No reply to this affidavit in opposition.
Reply, it was called for Lordship in the morning.
Oh, this one. Article 21 is not going to help you out. No Article 21.
Paragraph 6 of my reply, Lordship, I have stated that I denied the statement that I am carrying on the business, and the respondent has put to strict proof. It is vague statement made in the affidavit of opposition with regard to continuity of the business by the petitioner even after cancellation of registration. Because obviously I cannot carry on business. I cannot raise invoice. I cannot purchase any products. I cannot enter into any contract. I am a works contractor, Lordship. And being a works contractor, it's not a position of regular business, Lordship. And as has been stated by my learned friend Lordship, my old payments are because of the cancellation also. My old payments are all held up, Lordship, as submitted by my learned friend. Because of cancellation, all
You
payments
don't
are
want
held
the
up.
money, no? Therefore, you have approached in 2024. Why should this court at all exercise 226 delay in laches? One fine morning, you have woken up, okay, you can move the High Court. They are just waiting out there. They have no other work. Mr. Gogoi, are they carrying on any business? You have made a statement which they have denied.
No, my lord, it says, my lord, the deponent basis said that the petitioner, if continuing, we are not saying definitely. If continuing business, he should close the earlier registration by filing final return as per the provision of the act by paying all his dues in the said return, and thereafter can obtain fresh registration. That we are saying. Even if we are continuing today also, there are provisions, my lord, we can act upon, my lord. Even somebody is, my lord, running business without registration, we can, my lord, definitely.
You
After
can
nine-
sue to register him.
Yes, madam. That, but the tax and all will have to be paid. So far as the earlier registration, that will go, it will not be manual revived. That will be a fresh registration. And Lordship will see manual 2019, it has been manual cancelled. He has preferred the appeal in manual, March 2024. Now he says that manual, we are at fault in rejecting the appeal. Can there be a ground for 5 years manual, he is manual? And he says that manual, being a businessman, he's not, he doesn't manual check the portal and all. For 5 years, he has not checked it.
What business does he do?
The works contractor, Lordship.
Huh?
Works contractor.
You did not move for under 30. You move under 107.
Exploration.
I moved under 107, Lordship.
How? Not under
Because,
30.
because the time limit was only 60 days, Lordship. That the time limit under section 30 was 60 days only.
And
So that was
107 is 90 days.
Lordship. But there is a sometimes the extension they give extensions, Lordship.
Mr. What do you say about paragraph 11 of your petition?
Lordship, that refers to the past pending bills and contracts, Lordship.
Hmm?
Paragraph 11, I refer to
Will
the
not be able to raise any bills, invoices or enter into a. You say that there is no reapplication of fresh registration.
fresh basis. Because
Is it your case
being a
anywhere?
defaulter,
Is it your case anywhere in your writ petition that you would not get the ITC? No. Yes, other councils waiting, why? Others may go.
Lordship, my client is ready to give whatever your lordship puts any condition for invoking his reason. Even 10% is ready to give. Lordship, but in lordship, he is lordship a simple, very simple person. Lordship,
He's simple person, then why didn't he file?
no, lordship, I have a reason, lordship, because I never
You
received my
better
proposed
go for
notice.
fresh registration. Mr. Toti. That's not your case even. Your only issue out here is that without a registration, your right to carry on business would be affected. You say that there is no possible for a re-registration. You apply for registration, they will grant you.
Being a defaulter lordship, registration is not there. And once I, being a defaulter lordship, registration is not, will not be granted. And
But the
once I,
question is, you show them that you have not carried on any business. That's all. I'll pass that order to their effect. If you show that you have not carried on the
but so
business,
far the pending returns are concerned lordship, unless that is done and up-to-date returns are filed.
that is always permissible to file. If you see that
But because
form,
of the
no,
cancellation, I'm
section
unable to file.
29, it categorically says,
It says, but on the portal, I cannot file it, lordship.
no,
That's the
section 29, it is categorically mentioned, see, and you have no work. What is the pending? Only those 6 months.
Nil return has to be filed, lordship.
No, kindly see, the cancellation of year or the demand, as the case may be, shall be deemed to have been cancelled of the registration under this act. The cancellation there shall not affect the liability of the person to pay tax and others so and so to discharge the obligations under demand and thereunder for any period prior to the date of cancellation, whether or not such tax or year are determined before or after the cancellation.
Right.
So you'll be liable to pay.
Right, that I'm willing to do. I'm willing to do that, lordship, with all the.
After that, you have not carried on business as it is your statement.
Yes, so nil return has to be filed and whatever is due, I.
No, do you have to submit any nil return? Doesn't require because your license has been cancelled. If you have not done any business, Mr. Goy, he doesn't have to pay anything. If you have not business out there, nothing.
There's a nil return.
Nil return. But how will he file a nil return? Can he file a nil return on a and cancel
Portal
the
doesn't
registration?
allow it.
There is a provision, my lord, there is a provision, you have to pay. Even, my lord, for those persons that have submitted, my lord, who have not been registered, they will also have to pay, my lord. If at all there is a business carried out.
There is a provision to
Yes.
the effect. So therefore, I'm saying
Yes.
there is a requirement to pay. How it is to be paid. And the other matter is where?
Lordship, in my case, lordship, what has happened is that they have issued me a so-called notice in their lordship. The portal it is shown, but lordship it never opened. And lordship in the affidavit also they have not denied that it was never opened. And it was a 7 days notice they had sent to me, and within 7 days they had cancelled my lordship registration. Then it was a glitch in the portal. Lordship, after the petition has been filed, that glitch has been removed now in the year 2024. So at that point of time, lordship, we were not aware what is the reason for cancelling my registration. In Annexure 3, lordship, page 46, I have given the screenshot of the lordship portal. Lordship, may kindly see that the SOCOS notice, Annexure 3, page 46, the SOCOS notice is bold, and other which I have opened is lordship light in color, which I am able to open. This SOCOS notice never opened, lordship, because of which, lordship, I was not able to reply to that SOCOS notice, and my order was cancelled in lordship 7 days time.
Where is the cancellation?
Lordship, next page 47. Lordship, from this it has been written. This has been referenced to your reply dated 8/7/21 in response to the SOCOS notice dated 29/6/2020.
So here also no reply.
Lordship, whereas no reply to the SOCOS notice has been submitted, they have said that no reply has been submitted. But how will I submit a reply when I did not receive the SOCOS notice? Because it never opened in the portal.
When was this?
Lordship, this was
21.
Lordship. Thereafter, I have given money to my lordship, my
Oh, you're a
accountant.
chartered accountant, that person
Yes,
to
yes,
submit.
yes.
I
He did not
remember
touch it.
now.
He did not lordship file the lordship appeal. I have given the money to my accountant. Thereafter, I filed the appeal and it has been dismissed on the ground of delay.
Rightly so.
Lordship,
Lordship,
section
lordship,
45.
this lordship,
Section 45.
Section 45.
Final return.
Every registered person who
What
is
the funds
required to
return of-
furnish return on the whose registration has been
Whose
cancelled
registration
shall
has been
furnish the
cancelled?
filer within
They'll
3
furnish.
months of the date of cancellation or the date of order of filing, whichever is written. Now, what happens now? Notice to the return defaulters, where a registered person fails to furnish return under IMAN, a notice shall be issued requiring him to furnish IMAN. 15 days. Any registered person who fails to do so and so, man, any unregistered year. So this is only for those persons who are registered and who have been cancelled. Now, if he doesn't file within, then you have to issue a notice. Have you issued notice? Hello, we'll take it up again on Thursday, huh?
Sure.
Next Thursday. How many matters are there?
Item 9 is.
Yours also.
Item 9.
6, 7 and 9. 6, 7 and 9.
There is also.
Okay, all this.
6, 7, 9 and 10.
Can it be on Wednesday also, 25th?
Oh.
25th also.
Wednesday, it is a 3-minute affair. Thursday, will hear you more. Give you option. The same matter, if it comes up on Wednesday, I'll finish it up. 3 minutes.
It I'll rely upon the of my learned counsel, because Thursday I won't be here.
No, it is not that this court doesn't, but show me a way by which something can be done, because otherwise this will open again another floodgates. One has to be very careful.
Sometimes floodgate should be opened in this type of cases, Lordship. I am not a person, Lordship, all these dealers, these 4 people who are before this Lordship are not dealing in circular trading. Lordship, they can cancel this Lordship provision which has been filed, which has been put into the picture is because some people are dealing in circular trading. They are issuing fake invoices. We are not dealing in fake invoices. We are genuine dealers who are paying taxes to the government. So, Lordship, cancelling their registration and putting such stringent Lordship laws, and we are ready to pay to them. Lordship, in my humble submission, and everybody has some reason for that. Otherwise, the people.
When the act says, because see, otherwise what is happening, there are far-reaching consequences. The other person is suffering. That day I was getting on another matter, where because of this 16(2)(b), this person was not getting the benefit. Is that the Anodhya matter? So she was saying that, you see, that person did not submit the return. And because of the return not being submitted, I have been harassed. And I am not getting the benefit. That is the way. However, the division bench made some observation in that. See, when there is a challenge to 16(2)(b).
Yes, yes. The division.
That
bench
is
are down.
another thing. But how do you take care of this situation? Because you see, if you come immediately, it's okay.
Yes, sir.
This court can die. If you're coming after 5 years, we take care. Means it means, and the moment I allow it, goes back to the date on which it is there.
In my case, it is 2 years, but I was taking steps. What I will solve from all the cases. On all my, I was keeping on taking steps. Lordship, within 2 years, I had filed the appeal before the appellate authority. That was
2
rejected.
years is too long.
Lordship, in 2 years, Lordship. But